Yes, Mr. Das, please try to be on mic. We are in a different system now. Yes.
Am I audible, man?
Very good. Still not audible. Talu karantu. While you are speaking, you are letting your head down. So, yes, what is
On the point of while she was attending majority of age, both the husband and wife, that is the case. They fled away from their residence from Dhenkanal. The marriage, a police case was
Hey,
there.
what was the nature of dispute? Why are you taking us to the story? What was the nature of dispute?
That they have alleged
It is 13 or section 9
no special
or
marriage,
12.
no special marriage act, my lord.
Special Marriage Act for what?
Section 24 to declare that the marriage certificate issued by the authority is a void one.
Is a void one.
Void one. That was obtained.
So that has been denied or allowed?
That is, the case has been dismissed, my lord.
So that was answer straight. So wife's request for declaring the marriage certificate null and void has been negative.
Negative.
Negative. Admit. Admit. Call for LCR insurance. Requisites as undertaken be filed by Friday. The line is insure soribo kon eତେ করছো?
Item number 2, my lord. This
Yes.
appeal, which is arising out of a common judgment, wherein the husband preferred a petition under section 13(1)A and 13(1)B, AB,
Both
cruelty and desertion.
Cruelty and desertion.
And after filing this case, after 3 years, wife filed a petition for restitution of conjugal rights under section 9.
Both have been decided in a
common proceeding, wherein, my lord, my divorce petition has not been allowed, and her section 9 petition has been allowed. So therefore,
you are the husband.
I am the husband. Man.
What was the date of marriage?
The date of marriage, my lord, was way back in the year. For 7 years, my lord, they are not in. This is in 2013. The date of marriage is 3/6/2013. 3/6/2013.
What is the date of desertion?
From 2015. Date, my lord, I'm July 2015. 29/7/2015. And parties are residing separately for last 7 years. Both of them are class 1 officers of the state government.
That usually happens.
Class 1 officers of the state government.
That usually happens.
Yes,
conciliation taking place fails.
Yes, my lord.
So that's a normal feature. Once parties are in litigation,
yes, my lord,
nobody is joining the other.
They fight the marital battle, my lord, for such a long time.
Why is showing interest? What are you doing?
Both of us are class 1 officers, my lord.
Class 1 officers. So why are you not joining?
She does not wish to join. She goes to
What is that allegation on cruelty?
She goes to Supreme Court even to cancel my bail. She ensures that I should be put behind the bar. She ensures that I should not be there in Bhubaneswar. She keeps me transferring from one place to the other. I'm there, my lord. She says that you can't stay with your parents. You can't bring them to my home.
Admit it is for first time.
Well, first time.
It is for first time. Then how there has been so many markings? There has been so many markings. This.
I'm so sorry, my lord.
Certified copy judgment.
I'm sorry, my lord.
Important is there. Marking important there.
Certified copy maybe after marking you that has.
I'm sorry, my lord. I'm sorry. I'm so sorry if that has been done, my lord. I'm so sorry.
Erase it out, please.
I'll do that,
Court
my lord.
master. Erase it out. Be careful, because if they go on marking, then where is the space for?
I'm so sorry, my
Oh.
lord. So sorry.
That's why I thought maybe this is coming for second time. What is the interim petition in the divorce proceeding?
My lord, what has happened is section 9 petition, since it is allowed
Hmm.
and has been given that liberty to execute it.
Huh?
She has been given that liberty to execute the restitution of conjugal rights.
That is.
For last 7 years, she is one after the other cases she is filing.
Is it a strange case here?
My lord,
Is it a strange case here, looking to the marriage dispute history?
my lord.
Is it a strange case here?
My lord, I completely
Both
bowed
are
down.
educated, highly educated.
Inflated
therefore,
king size ego, my
applies
lord.
their mind.
Inflated king size ego.
And these things happen. Admit. Dita matter independent order. It first case to admit, call for LCR insurance. This case it will be let notice go. Interim aspects shall be had after the appearance of the wife, the respondent herein. Aratory be same order. Setira call for LCR rohibani to iterate of Dita case last. Place the interim application immediately after appearance of the wife. You make personal endeavor, because they hardly 1.5 years or 2 years they stayed together. And for us, separation after 2 years of marriage.
Item 3. My lord, in this case, damn for the wife, and it is just a reverse case of the previous one. The husband, my lord, here is applied for divorce. From kindly see, my lord, annexure 1 is the day-to-day order sheet I have filed. It is expiry decree. From 2015 to 2019, she was absent before the court. In his absence, it is admit. My lord, kindly see first order, 18/5/2015. The petitioner is absent, admit, issue summons. My lord, thereafter continuously he was absent up to 2019. And 2019, my lord, the page 13, my lord, kindly see, 7/10/2019. The petitioner is present. He is examined as PW1.
Madam, you have to appreciate,
My lord.
even after filing the case, he was not pursuing for long.
Long time.
Maybe with a hope there will be reunion.
No, my lord, 2017, the wife was with him only. And he has filed 2015. From 2019, my lord, kindly see, cross-examine.
While the wife was residing with
Now
the
he's-
husband, the petition came. Douglas, you
My lord, that I have not appeared there.
You have not appeared, expert is. Restoration file colony? Refuse it.
My lord, in
All right, let us issue notice. Just 1 minute. Certified copy there. All right. Issue notice expert is early hearing set aside. Yes, all right. I had issue notice on the question of admission, keeping in view the matter application is against an expertise order, and further also order declining to restore the expertise proceeding. To find early disposal of such case, this court direct filing of requisites by tomorrow. Notice be issued to the husband fixing short returnable date. Matter may be placed on 23rd of August.
My lord.
Pass over, your lordship. Pray for pass over. Pray for pass over, your lordship.
Adjourn, Hon'Ble.
Your lordship, pray for pass over, your
But
lordship.
it will come next week. Next week.
Sorry.
What, you will place?
My
ଆପଣ ଆଖି ଧରିଛି
I guess.
ପଳାନ୍ତୁ ବାହାରୁ ତୁରନ୍ତ ଯାଆନ୍ତୁ next Tuesday ନବା କେସ୍ ତୁରନ୍ତ ପଳାନ୍ତୁ don't give pain to your lawyer friends. Please go back to your home. You are acquainted in arguing from home itself. Why have you come to court? Yes.
Item 5.
May I please, your lordships?
এটা-
My lords,
এটা
pursuant to the direction of my lords, the respondent has appeared.
Okay, it will
before
be
your lords.
taken up at 12 o'clock. Chamber ରେ ନବା এটা ବି close ହେଇଯିବ এটা ବି close ହେଇଯିବ ଏ ପିଲା ପାଇଁ ଦେବେ। Yes, item 6.
Your lordships, there are some defects. I may be permitted to withdraw, remove that.
Pardon?
There are some defects in item number 6. I may be permitted to remove that in
But
course.
how long this will go on?
Lordship, today.
Matter IA notice has been issued.
Yes.
Then another date, then admit the ହେଇସାରିଛି।
Again,
So এটা orders ରେ ଆସିଛି କି?
again.
ହଁ 5 ଚାମ୍ବର ଦିଆ ହେଇଗଲା ଆମେ 6 ଧରିଛେ ପରା 6 ନା ଓ 6 119 ଓକେ Effect.
That I don't know, but in cause list it is showing.
4.50 ଦେଇନାହାନ୍ତି।
The lagging to.
All right, you undertake to deposit it in course of day.
Yes, yes, today I'll.
Then argue what is the matter?
Your lordship, it's a.
What is the matter? Admit ହେଇନି ଏପର୍ଯ୍ୟନ୍ତ. What is the matter? You are for wife?
Yes.
Okay, what is the proceeding?
Order dated 28/3/2023, passed by the learned family judge Kendrapada in civil case, no civil proceeding number.
Madam, that's not the way to argue, madam.
Yes. Let
First
me
you are to
place the matter.
First you are to clear what is the proceeding in it. What
Section
happened there?
in proceeding was before the learned
Petition
family
for
restitution of conjugal rights.
restitution of conjugal rights. So start with that. Who had brought that application?
Husband was filed the.
So husband's application, restitution of conjugal right
Yes.
has been allowed or rejected.
Allowed.
Matter finally, unless we release those.
ଯେବେ ଆପଣ କହିବେ ଯେବେ ସୁବିଧା ହବ
So let it come 2 weeks after,
ଯେବେ ଆପଣ ସୁବିଧା
2 weeks after.
Lordship may fix a date mill.
I'll know about.
Lordship may fix a date mill.
এটা কোন রিমান্ড রে আসছে?
ନା ନା
Ah, no.
ଚ୍ୟାଲେଞ୍ଜିଂ ଦି ଆୱାର୍ଡ ହେଇଗଲା
ନାଇଁ
ନାଇଁ ରିମାଣ୍ଡ ନାହିଁ
what is the direction of Hon'Ble Chief Justice?
ନାଇଁ ସେ ଜଷ୍ଟିସ ମିଶ୍ରଙ୍କ ପାଖରେ ଥିଲା SK ମିଶ୍ର
Oh,
and
that
Justice
can't
Sinha।
be hard.
ସେଥିପାଇଁ cannot be hard।
Also kindly mark true copy of the honorable order of the honorable Supreme Court flag P.
There
That is in a
that was
different
directed
issue,
to complete the proceeding within 4 months. That
Not
was passed
possible.
in the year 2017, Miller. That
So
order
that
was
four
passed.
months,
By the
Formal-
tribunal or by the High Court?
No,
By the High Court.
What is that?
Somebody who is not connected with the matter, he had gone to the Supreme
No,
Court।
no, he is
That is the right.
he is the workman.
No.
He is the employee. He is also agreed by
Your lordship fixes a date।
the state.
2 weeks after date, they have
Again.
same day,
Date.
same day.
Huh.
weeks after Wednesday.
Wednesday. Grateful.
So 9, my lord, your lordship will kindly see the order dated 6/7/2023.
Six, 7/23. Yes. Yes, so whether this 5 lakh has been paid?
Yes, yes.
Paid.
She paid and she has also received.
So previous occasion, you offered 20 lakhs.
Again. And
I have filed an affidavit to that effect.
Affidavit flag.
she is not ready and willing to take permanent alimony.
Okay, affidavit flag कहते हैं.
Again.
Flag B.
ସେଇଟା ନୁହେଁ ବୋଧେ ଆପଣ decide କରୁଛନ୍ତି।
Oh, you have added all these outstandings also. She said, she made it clear, I'll be paying over and above 20 lakhs.
My lord.
So why are you
No, I have
advising your client to
No,
file?
I have filed a recent affidavit on.
No, tell us what is the amount you want?
She is not agreeing. She is not agreeing for
She
permanent.
is not agreeing
Not
to
agreeing.
20 lakhs even.
Even.
Over and above the payment
He
already
is
made.
saying permanent alimony, I am not agreeing.
ଆଉ କଣ ନେବେ?
It says that appeal be proceeded with on its own.
ଠିକ ଅଛି, hearing ହବ ଯେତେବେଳେ ହବ all right.
Hello to
By order date.
My lord, your lordship may hear me for a moment.
No hearing possible now. No hearing possible.
This
You wait for
appeal is
your
not
turn.
at all hard. This appeal is not at all hard. Finally.
So, Mr. Could you get what fell from my lord?
On 6/7/2003, this bench, while recording the preparedness of the husband to settle the matter with a sum of rupees 20 lakhs as final, as further as permanent alimony in addition to whatever has already been paid. Wife bringing an affidavit by flag and counsel appearing through such affidavit contents wife is permanent alimony and she is very much enjoyed by the husband. In affidavit at flag sheet there appears there is some issue with regard to outstanding on interim maintenance, on the head of interim maintenance.
And that is, my lord, in relation to proceeding under section 125.
Yes, definitely. ଆମେ ଦେଖୁଛୁ ଆଜ୍ଞା 125 CRCP ସେ ଲେଖା ହେଇଛି। Patience କାହିଁ ରଖୁନାହାନ୍ତି ଏଠି ଆପଣ ମାନେ?
ଆଉ ବୟସ ଅଛି?
ଆଉ କାହାର ବୟସ ହବ ପେସେନ୍ସ ରଖିବା ପାଇଁ? ଏଇ ବୟସରେ ତ close the matter to give a final resolution by way of permanent alimony for the wife declining to accept such offer. On the so this observes the matter needs final hearing. Voilà. On the aspect of outstanding on area interim maintenance, this court leave it open to the parties to approach under appropriate proceeding for realization of area if any. And a matter stand released will be listed in due course. In its own turn.
ଆଜ୍ଞା ଗୋଟେ ଡେଟ୍ ଟେ କରିଦିଅନ୍ତୁ ଆପଣଙ୍କ।
Date ମୁଁ କାହିଁ କରିବି ଆଜ୍ଞା, ମୁଁ ଶୁଣି ପାରିବିନି, ମୁଁ ଥିଲା ଭିତର ରିଲିଜ
ତିନିଟା ମ୍ୟାଟର ଅଛି।
all three matters.
ତିନିଟା ମ୍ୟାଟରରୁ ଲାଷ୍ଟ ମ୍ୟାଟର ଦେयर ଇଜ ଆନ୍ ଇଣ୍ଟରିମ୍ ଅର୍ଡର, ସେଟା ଏକ୍ସଟେଣ୍ଡ ହବ।
Pardon?
ଲାଷ୍ଟ ମ୍ୟାଟରରେ ଦେयर ଇଜ ଆନ୍ ଇଣ୍ଟରିମ୍ ଅର୍ଡର।
Interim order to continue wherever. ହେଲା all three matters verify କରିବ wherever interim order to continue. ଦେଖିବେ order sheet ଦେଖିକିରି continue କରିଦବ ହେଲା।
May it please, my lord. My lord,
Yes,
the
10 again.
my lord,
10 କଣ ଏ final hearing?
ନାଇଁ ମୁଁ ଫାଇନାଲ ହିୟରିଂ ଦରକାର ପଡିବନି।
ଆଉ
ଏଥିରେ ଆମେ ଡିକ୍ରି ଅଫ ଡିଭୋର୍ସ ଆଣ୍ଡ ଆଲିମନି କମ ଗ୍ରାଣ୍ଟ ହେଲା ବୋଲି we came before this noble court in appeal.
enhancement.
During the course of appeal, it transpired
5-4 ପରେ considering recording of this court even on the submission of counsel for husband showing his readiness to give at least a sum of ₹7 lakhs as permanent alimony, this court, while deferring the final argument of the matter on its own term, direct the husband to deposit sum of ₹7 lakhs by way of a draft in view in the name of the wife involved herein being prepared in a national in the name of wife. And the deposit should be made, the draft should be handed over to the registry of this court at least within a period of 2 weeks. On the deposit being, on the submission of the draft, on a proper application, the amount may also be released in favor of the wife. Following procedures required for the same. Receiving this amount shall retain a sum of ₹3 lakhs in our account and shall make a fixed deposit in favor of the minor child on the balance amount of ₹4 lakhs. Fixed deposit for at least 3 years in a nationalized bank, and submit the fixed deposit, the certificate of fixed deposit in this court within 2 weeks further. This order, the order for depositing by the husband is passed keeping in view the litigation presently confined to permanent alimony alone, and with a view to protect the minimum sustenance of the wife and the minor child involved here. Yes. have the liberty of utilization or uh, keeping in deposit on the amount on the sum of rupees 3 lakhs.
Your lordship push adjourn or dispose con adjourn
7 ଲକ୍ଷ ଟଙ୍କା ଆପଣ ଯୋଉ ଦେବେ ବୋଲି ପ୍ରିପେୟାର୍ଡ ଦେଖେଇଲେ
ଆଜ୍ଞା।
ସେ 7 ଲକ୍ଷ ଟଙ୍କାଟା 2 ସପ୍ତାହ ଭିତରେ ଡ୍ରାଫ୍ଟ ଦେଇଦେବେ।
2 ସପ୍ତାହ ଟି ଟାଇମ 7 ଲକ୍ଷ ଟଙ୍କା ଦେଇ ପାରିବନି ଏକାଳି।
ଆପଣ 7 ଲକ୍ଷ ଆମେ ରେକର୍ଡ କରୁଛୁ
ହଁ ରେକର୍ଡ ମୁଁ ଦେବି 7 ଲକ୍ଷ ଦେବି କିନ୍ତୁ ଏକାଳି ଏଟେ ଷ୍ଟ୍ରେଚ ଦେଇ ପାରିବ।
4 ସପ୍ତାହରେ ଦେବେ
ହଁ 2 ମାସ
ନା ଦିଟା ଇନଷ୍ଟଲମେଣ୍ଟ ରେ 4 ସପ୍ତାହରେ ଦେବେ।
ଦିଟା ଇନଷ୍ଟଲମେଣ୍ଟ 2 months ଦିଅ।
2 months all right we don't do ତାହେଲେ ଲେଖି ଦିଅ। This court records the submission of Sri Nandi ମତେ ଦବ ମୁଁ ସଜାଡ଼ି ଦେବି ହେଲା। Nandi who undertakes to for the financial constraint at present undertakes on behalf of the husband to deposit the sum of rupees 7 lakhs in 2 equal installments in 2 months. This court therefore directs the deposit of the first installment sum of rupees 3,50,000 before the registry in shape of bank draft in favor of the wife by 18th of July. 18th of August. 18th of August, 1 month first installment. Similarly, the second installment will be deposited by 15th of September.
Last week of September.
2 ମାସ କହିଲୁ ଆଉ 2 ମାସ ବାହାରକୁ ପଳଉଛି ନା 2 ମାସ ବାହାରକୁ
ଚାକିରି ପାଇବା ପଇସାଟା ହଉଛି ଲାଷ୍ଟ।
ଶୁଣନ୍ତୁ ଆଉ ଆପଣଙ୍କର ବୋନାଫାଇଡ୍ ଦେଖେଇ ଦିଅନ୍ତୁ। That will help you rather. Yes.
But the order regarding utilization remains, my lord.
Again?
Order regarding utilization of
spread କରିବାକୁ ପଡିବ।
Utilization ଆମେ ସେ ଅନୁଯାୟୀ କରିବୁ receipt of the amount ଆଗ ଯୋଉଟା ପାଇବେ ସେଟା ଝିଅ ନାଁରେ FD କରିଦେବେ ଆମେ କରିଦବୁ। ହଁ ତା ପର ଟଙ୍କାଟାକୁ ତ ଆପଣଙ୍କୁ ଲିବର୍ଟି ଦବୁ to spend in your own way. Yes. କରିଦବା ତାହେଲେ ସେ ଅନୁଯାୟୀ ସଜାଡିଦବା। ସେ ପର୍ସନଟା ସାଇଡରେ ୟୁଟିଲାଇଜେସନ ଆସ୍ପେକ୍ଟଟା ଯୋଉ କହିଥିଲି ଡିପୋଜିଟ ରଖିବା ସେଟାକୁ ଏଇ ଅନୁଯାୟୀ ଆମେ ସଜାଡିବା ହେଲା।
Then your lordship posted to your lordship posted to କେବେକୁ ରଖିଲେ?
ରଖିବା କାହିଁ ରିଲିଜ ତ କରିଦେଲୁ ଆଉ ରଖିବୁ କାହିଁକି ସେ ତ ରାଜି ହଉନାହାନ୍ତି। So hearing ହବ judgment ହବ it's not possible by us. ଆମ ହାତରେ already judgments reserve ଅଛି। ଆଉ matrimonial appeal ରେ you can't expect ଆମେ every week ରେ 3ଟା judgment ଦବୁ।
ମିସଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ହେଲା ମୁଁ 7 lakhs ଟା ଫର ଫାଇନାଲ କହିଥିଲି ଆପଣ ସେଟାକୁ ଇଣ୍ଟ୍ରିମ୍ କରି 7 lakhs is a final।
No final ହେଇପାରୁନି।
ଆପଣଙ୍କ ଇଚ୍ଛା ଆପଣଙ୍କ
ଆପଣ ଦେଇଦେଲେ ଆମେ ଲେଖିଛୁ ଆପଣ ଏଟା ଫାଇନାଲ ସିଏ ଆଗ୍ରି କରୁନାହାନ୍ତି ଆମେ ଲେଖିଲୁ।
ଆମେ ଯଦି 70 କହିବା ଆପଣ ଦେବେ କି?
ଦେଖ ଆମେ ହିୟରିଂ କରିବୁ what should be the viable amount ସେଟା ହିୟରିଂ ଆଉ in the meantime ରୁହନ୍ତୁ in the meantime we find since we find the affidavit is not in terms of what is that judgment reference ଟା ଦେଇଦବ। This court direct the husband respondent herein এটা wife no sorry husband টা appellant না husband is respondent to bring appropriate affidavit strictly in terms of this
that is 2021
ଗୋଟେ ସ୍ଲିପ ରେ ଲେଖିକି ଦେଇ ଦିଅ ହେଲା ଆପଣ 3 ବର୍ଷର ଆଣନ୍ତୁ So court will take a justified decision. Now it is left to the court. What should be the amount?
Yes.
Yes, next.
May I please?
Item 11.
May I
Madam,
please?
you are struggling every day. You are for wife.
Yes, my lord. My lord,
Who
appellant
is for husband? Husband is not turning.
no.
Expertise already.
Expertise, notice issued in special
So
messenger.
admit hela. Admit ହେଇକିରି stay ହେଇଯାଇଛି. Okay, dispose କରିଦେଲେ in view of the order ଏତେ.
Refuse to
Okay,
receive.
then what is the service aspect?
In court.
Then all right.
In- Court below maintenance case is going on.
Huh?
In court below maintenance case is running. Court.
Forget that. We are not on that issue.
Yes, yes, my lord. My lord,
Witness
in
case
that,
is running or walking, that is for the trial court.
but he is not paid properly. My lord.
Oh, Seta, can that be issue here, madam? Please be fair, be fair enough.
Yes,
That's a different proceeding before a different authority. You
yes.
can't step in there. So I'm a kind of argument allowed. Just now you said section 9 with an intention to escape the maintenance.
Yes,
Now
my lord.
husband is ready to take. Why are you not joining?
My lord, my marriage is solemnized on 2000 to 2000. Till 2012, we live happily. Then my respondent is kept another lady. So she left the house of her parent with her 2 female daughters. Then since then she stayed there.
Okay. Bring your pleading in the objection to section 9.
Yes, my lord. I am in court below, not taken into consideration about the
Let us see your plea that she has already a concubine or concubine definitely, because there is no resolution of the marriage as of now.
Yes.
So have you taken that stand or you are arguing just here?
No.
Where is that copy? LCR aschi ki?
LCR with
Okay, delo LCR diyo. So that's your submission, that since she has already with another girl,
yes, my lord.
therefore it is difficult on your part to
stay
be a
with
part in the conjugal life.
Yes, my lord.
Conjugal life maintain kariba difficult hochi. This is
Yes,
your
my lord.
submission.
For which I am a fair lodged in that regard.
All right, even assuming your prayer is accepted, we can, if we interfere in the section 9 restitution of conjugal right order, how do you gain? How do you gain? What will be your position at that stage?
No.
You are separate.
So I am now living separate.
Huh?
I am in separate from respondent.
So you will live
no-
separate. There is no issue.
I am not.
Even in sustaining this order also, there is no enforceability.
No, my lord.
Nobody can take you or
Check,
leave you back to the custody of the husband.
Yes.
So you stay separate whether it is interfered or not interfered. So why this litigation? Why should you invite us to give a judgment in this nature of matter?
To set aside.
Undisputedly, you have not filed any petition for divorce. Even though you take a stand, even though you take a stand that she has a concubine, it is becoming difficult on my part to lead a conjugal life.
Yes.
But you have not come forward. So therefore, it is allowed, it is sustained or taken out. Section 9 order sustained or taken out. How do you gain?
Now, in this case,
So this is unnecessary litigation for us.
Yes, my lord. But
You continue with your life, you don't join.
he is not interested to go join with
If she is not interested, then what is the course left to you? ଆପଣ ଏଇ ଯୋଉ ଲେଉଟିଆ କିଆରି କରିକି ଚାଲିବେ ଲାଇଫ ଯାକ।
understand what you are, what sort of petition you have filed, what is the consequence?
Ultimately, what are you gaining? Then, WC लिखी ना दी. The expertise or in a contest?
contest.
Contest.
ଆପଣ
So,
ପାଖରେ pleading
court-
ଅଛି କି? ଆପଣଙ୍କ ପାଖରେ pleading
pleading
evidence
ପଢିଲେ-
ଅଛି? ଆପଣଙ୍କ ପାଖରେ କଣ ଅଛି?
ଆପଣ pleading
WS ଟା
ପଢିଲେ,
ପଢିଲେ କୋଉଠି କଣ କହିଲେ?
ଆପଣ ଏଇ ଅଭିଯୋଗଟା ଆଣିଥିଲେ ସେଠି,
ଆଚ୍ଛା।
so that there was a question for, there was a situation for considering this aspect. ଆପଣଙ୍କର ପଢନ୍ତୁ pleading. ଏଟା କଣ ଗୋଟେ page 2 ରୁ ଆରମ୍ଭ ହେଲା, okay, all right. ଏଟା section 9 petition.
Yes, my lord.
ଏଟା section 9 petition. Yes, madam, there is no written
Yeah.
statement.
Yes, my lord. In my deposition,
Filed.
LCR.
Provide us a copy of the written statement. Because the LCR nine written statement copy. Okay, let us, what the court recorded, let us see. Trial court can't record kala dekhala. Petitioner is ready and willing. OP entered appearance in case filed or so cause. File first. Where is the so cause thing? Power petition Hajira. Petition filed by OP. এটা তো introductory application. ନା ଆଉ କପି ରଖିନାହାନ୍ତି?
LCR.
Examination in chief, this is evidence. Evidence we are getting. Where is your objection? এটা petition under section 9. Just 1 minute, let us see. You have got a Xerox copy of written statement.
No, my lord. This
सभा लास्ट को अच्छी देखंतु आपण जो कॉपी हमको देले तार शेष आडू को अच्छी सेटा
not with me. This is the only copy.
This is the only. All right, let us go. Thank you. Lady not safe in the you have got, yes, we got it in para 3 and 4, you have clear statement.
Yes, ma'am.
Not only she has got a concubine, but your life is also not safe.
Yes, ma'am. And then para 8 also, my
ବର୍ତ୍ତମାନ
lord.
ଜଜମେଣ୍ଟ ଟା ଦେଖନ୍ତୁ କୋଉଠି ସେଟା ଡିଲ୍ ହେଇଛି ଯୋଉଟା ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଏଇ
This is
ପୋର୍ସନ
not
ଟା
taken-
କୋଉଥିରେ ଜଜମେଣ୍ଟ ରେ ଡିଲ୍ ହେଇଛି ସେଟା ଦେଖନ୍ତୁ
This is not taken into consideration. Account niya hai nahi.
ହେଲା ଆଜ୍ଞା ହେଲା ଆପଣ ସେଟାକୁ ପଏଣ୍ଟ ଆଉଟ୍ କରନ୍ତୁ
Where has he considered that?
Page.
ଆପଣଙ୍କ written statement ବିଷୟରେ ସେ ଲେଖୁଛନ୍ତି ଏଠି ଦେଖନ୍ତୁ para 3. Please read para 3 of the judgment.
Para
internal page 3
3.
internal page 3 para 3
And running page 9.
running page mark କରୁଛି mark
9.
3.
Read.
Running. That the OP entered her appearance, my lord.
ପଢନ୍ତୁ
The OP entered her appearance in the case and filed her show cause. She submitted the marriage and regarding her children.
Submitted ଲେଖା ହେଇଛି
Admitted, sir.
40 ଛୁଇଁଲାଣି ଚଷମା ବଦଳାନ୍ତୁ
Further, according to her, the petitioner had kept extramarital relationship with a lady, namely so and so.
now come to, yes, already he has taken note of that. Now come to his finding. Why has he discussed at all on this?
Not taken in this consideration, my lord.
ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ରେ କହିଲେ କି ଏକ୍ସଟ୍ରା ମ୍ୟାରିଟାଲ ଲାଇଫ ଆଣିଲେ କି?
Evidence, my lord, I am already.
Evidence ଦେଖନ୍ତୁ ଟିକେ
Yes, we have some
I-
matters in chamber.
May I pardon to
two
mention? my
matters
lord?
କୋଉଟା
Two
କହିଲେ
matters.
May I pardon to mention?
Five?
my lord?
ଆଉ ଚାମ୍ବର କେସ୍ ଟା ରହିଛି ଅଲଗା ଲିଷ୍ଟ
ସେଟା ସ୍ପେଶାଲ ନୋଟିସ ଅଛି।
ନାଇଁ ଲିଷ୍ଟ ହେଇଛି ନୋଟିଫାଇ ହେଇଛି
କେତେ ଆଇଟମ ସେଟା?
ସେଟା ଏ ଗୋଟିଏ ଆଇଟମ
Oh, separate notice କରିଛନ୍ତି.
ଆଜ୍ଞା
So we hope
So
the
that-
other matter, the council and the parties are present.
May I pardon to item 12, next item. like,
ହଁ
Item 12.
ହଁ
ମୁଁ କାଲି ଟିକେ ରହିବିନି 2-3 ଦିନ
ହଁ
ଟିକେ ରହିବିନି 2-3
The
ଦିନ
date you can take. Date, it's maybe the next week. We can suggest the court master, he will give you the date.
my lord, oblige.
ଆମେ ତ ଚାହୁଁଥିଲୁ ଯେ ଏଗୁଡାକ ସବୁ କାଲିଠୁ ଆସିବ ବୋଲି। You want date?
ହଁ
ଆଉ date 4 weeks ପରେ ଦେଇଦିଅ।
Item
ଯିଏ
14
date
also-
ଚାହୁଁଛନ୍ତି 4 weeks ପରେ ସବୁ।
Item 14 same prayer, my lord. Item 14, my lord, I pray the time,
Time
12
4 weeks after।
my lord.
ହଁ ଯିଏ ଟାଇମ ମାଗୁଛନ୍ତି ଦେଇ ଦିଅନ୍ତୁ। ଯୋଉମାନେ ଟାଇମ ମାଗିବେ ସବୁ 4 weeks after ହେଲା। ବାକି ଯେତିକି ରହିଯିବ ସେଟା ଆସିବ। Therefore court master, be sure only one case is there in chamber. But then you made a confusion.
ଚାମ୍ବର ଗୋଟେ ଆଉ ଗୋଟେ ରହିଲା ଚାମ୍ବର ଯୋଉ ମାଇନର ଚାଲି ଆସିଥିଲା ଆଇଟମ 5 ହେଉଛି ମେନ୍ ଲିଷ୍ଟ
Mainly.
ଆଉ ଚାମ୍ବରରେ ସ୍ୱତନ୍ତ୍ର ଲିଷ୍ଟ ହେଇଛି ଚାମ୍ବର
So there are two cases in chamber. So where are those councils? Yes, item 5 ର council କିଏ ଅଛନ୍ତି? କୁଆଡେ ଗଲେ ସେ Mr. Jujhar Singh and Mr. Mahapaତ୍ର? ସେ ଜାଣିଛନ୍ତି। So special notice council, who are the councils? ଆପଣ ଅଛନ୍ତି? ଆର ସାଇଡ କିଏ? ଅଛନ୍ତି?
Inform କରିଦିଅନ୍ତୁ।
ସେଟା 12:05 କୁ ଫିକ୍ସ ହେଇଛି। So ଆମେ କୋଉଟା ଆଗ ନବୁ କୋଉଟା ପଛ ନବୁ ଆପଣ ଅପେକ୍ଷା କରିବେ ହେଲା with your party, right?
ଚାମ୍ବରଟା ସ୍ପେଶାଲ ନୋଟିସ ନୁହେଁ ନା
ସେଟା 12:05 ରେ କୋର୍ଟରେ ନିହାବ ବୋଲି ଲେଖା ହେଇଯାଇଛି।
ନାଇଁ 12ଟାରେ ନିହାବ ଇନ୍ ଚାମ୍ବର
ଆଉ ଚାମ୍ବର ତ ଲେଖା ହେଇଯାଉ ଚାମ୍ବର ନାହିଁ।
ଚାମ୍ବର
petitioner applied for mutation, my lord, sir,
Yes.
demarcation, my lord. That is dropped on the ground that the property in question is involved in the civil suit. Actually, thereafter, let's see,
It is an outcome of a civil proceeding.
no, my lord, it is not an outcome. The
How?
lordship kindly turn to page 27.
Yes.
26.
I,
rather.
27, I filed a petition before the same Tahsildar under Rule 43 that meant that on the ground that
For demarcation.
demarcation again. Drop kar dele. Thereafter, I submitted a petition for review
no.
of that order. That is pending, my lord.
But 40, Rule 43 is concerning review.
Yes.
Review in a mutation proceeding.
Pardon?
And say review 43 is concerned about review in a mutation proceeding.
No.
Yes. Original order, appeal, and
Mr.
review.
Bose, we are not expressing any opinion.
Yes.
Suppose an application has
No.
come.
What has happened, your lordship may kindly see page 26.
Yes, 26.
Yes.
Yes.
The
Keeping in
demarcation
view,
has been rejected. No. This has been passed in a demarcation proceeding.
keeping in view,
Keeping in view of the above submission of both the parties, it transpired that that plot applied for demarcation is a part plot of the mother plot of 4 involved in the.
so that
Above-
is a reason. That is the
Sorry.
reason he has assigned in rejecting.
Yes.
Okay, now you have filed a petition to recall this order.
My lord.
Where is the scope?
With due respect, my lord, Rule 43, my lord.
Rule 43, is it a scope in this contingency?
It says, man, under this.
Why? If you are agreed, you go ahead. Counsel Shri Patil and counsel for the petitioner. For the alternate, for Rule 43 of the mutation manual.
Okay.
Mutation manual.
Manual.
Service.
Rules.
Service OSS rules.
Yes.
OSS rules. Finding no scope to entertain review of this nature. 6, withdrawal of the writ application, however, with liberty to find appropriate forum for urging, continuing his objection involving such order, whether the requisition those stand dismissed as not entertainable, but however with liberty. Yeah.
I don't know to.
Lordship, kindly see the order dated 24/4/2023, where I have challenged the order passed by the Revenue Commissioner Annexure 6. I was the owner of the plot on 95 decimals, and that was reduced in the Hull settlement, for which I filed a revision application. But revision was
15B on the basis of what? What was the foundation there?
I have only confined now, not to, your lordship kindly see order dated lordship's order 24/4/2023.
Where do you find? Here.
Yes, my lord, in present writ
In this
application.
writ, yes, to the extent
To the ex-
mandamus to the state authority for providing the road provision. to
What
the
happened, my lord? I was the owner. That was wrongly recorded. Your lordship kindly see, they have already closed my road for ingress and outgress. I have shown the photograph annexure 8, my lord. And the report of the Amin also there.
Have you approached the competent authority?
No, my lord, I have not approached the company.
Then what can be done in a writ petition?
My lord, I have challenged that order in this writ application.
Now you have dropped that challenge.
Yes, my lord. Your lordship has directed me only confined
Why
whether.
should I direct? You
But
take,
the-
you withdraw this and take liberty. Listener wants to withdraw the writ application in order to avail the.
Well, what happened now? They have already blocked, my lord. Your lordship kindly see the photograph.
Then you make your mind clear. Then you continue with the litigation. Continue with that challenge. If you succeed, ultimately you may succeed. You yourself say, I don't want to challenge that order. Now you are pursuing a other completely different remedy, that my road is completely blocked. I may be facilitated. Where is the cause of action? Can a cause of action of this nature straightway come to High Court?
Your lordship,
Make up your mind 2 weeks after.
next week,
2 weeks after. Yes.
Item number 3.
May I please, your lordship?
Yes.
My lord, mutation on the basis of a civil court decree has been refused. Your lordship may kindly come to appellate order, page 9.
Yes.
Page 9.
Yes.
Page 9, third paragraph, my lord.
It is learned from the records of lower court that the appellant has received the case land through registered willnama from so and so, who has won the case land in RFA number so and so of the Honorable ad hoc additional district judge, but failed to execute the orders of the Honorable Court for entry in ROR in favor of within law of limitation. He holds that mutation proceeding is in the
Take notice, sir.
notice was issued, my lord.
Take notice.
Extra copies I have served.
It's all right, extra issue notice on the question of admission. Extra copies you have already served?
Yes, my lord, by order dated 12/5/23. 12/5/23.
State Council, yes, you have got any instruction?
No, as you, I've not received any instruction. The Lordship may grant me 3 weeks' time so that I can file the counter.
The only question to be required to be gone into is whether he can reject on this premises. It's appeal. 1 week after the date here. Well, in the meantime, State Council is directed to come prepared to make his submission. 10th date here. Yes.
Item 4.
May I please, Your Lordship?
Yes.
Lordship, in this case, the petitioner applied for given application under section 8A of OLR Act for conversion of the land, my lords. And as per 8A is very much clear that the issue is confined to whether that can be converted, agricultural land can be converted or not. The appellate authority did not give a single finding or did not utter a single word regarding that. And the 8A has clearly stipulated the grounds on which it is to be decided. Without going to those stipulation, my lords, the appellate authority has dismissed the 8A application by raising questions regarding the settlement of land. But the ROR has already been made in my favor since 2019. So the question of raising the settlement.
Take notice on that.
Oblige, my lords.
Appeal provision is there. 8A reject.
He has come against appeal. It is nomenclated, madam, it is nomenclated as 8A appeal. Is it appellate authority order or it is
Appellate authority order, my lords.
of the appellate authority? Sure.
Yes, my lords. Initially, it was before
8A, the appeal is under section 58.
Yes.
50. No, my lords.
But se lekhuchandi shunantu se bote 8A ru jehetu asichi OLR 8A appeal number 20.
Agya.
All right, they nomenclate in that way.
Oblige.
Place the matter immediately after filing of counter. Yes.
Copy.
Item 5.
My lord, only grant time for 7 days due to removal of defect.
So, the question of removal of defect, you have a pending application seeking disqualification of a sarpanch.
Yes, sir.
Yes, let the application be considered under section 26 of the Act. At the submission of land council for Christian State Council.
7 days time.
Considering pendency of application for collector under the provision of section 26 of the Gram Panchayat Act. This court find, while finding difficulty in entertaining repeats at this stage in the disposal of the same, direct the collector Valangi OP number so and so. In the event, is already in receipt of complaint by Annexure 4, page 19 of the brief, should register the same under the provisions of section 26 of the OGP Act and give a lawful outcome, however involving parties likely to be affected. Let the petitioner communicate the order of this court along with the copy of the writ application on the collector OP number 20, at least within a period of 4 working days. Yes.
Item 6.
May I please, Your Lordship? Madam, the petitioner's application under section 22 of the OLR Act has been rejected by the sub-collector Sodar Kotak Malik. The impugn order at
This
page
is a
21.
proceeding finally concluded.
My lord.
It is in rejection.
My lord.
All right, take notice. Private party is there. Yes. Issue notice on the question of admission. Requisite according to.
22 rejection to appeal ଅଛି OLR
22 ର appeal ନାହିଁ. OSS.
नहीं this is OLR
OLR
proceeding.
OLR
OLR 20 ହେଲା applicable.
OLR 22.
Yes, 58. This is look 58. Sir.
The limitation है liberty.
Go file appeal. Yes, liberty.
Liberty. Limitation है.
It appeal.
And the certified copy also I have filed in this court.
Huh?
The certified copy I have also already filed here.
Oh, yes, it will be returned.
My
Yes, undisputedly there is a statutory remedy of appeal. As the order involved herein under section 22 of OLR Act 1960. Yes. For statutory remedy of appeal, this court permit the petitioner to withdraw the appeal. Withdraw the writ application in order to avail the appeal remedy. Certified copy of impugned order be returned on obtaining Xerox copy of the same.
Okay.
In the event appeal is filed within 2 weeks, along with condonation delay application, delay shall be condoned and appeal will be decided on its own merit.
2 सप्ताह भीतर फाइल करियो लिमिटेशन कंट्रोल हो.
Item 7.
May I please, Your Lordship?
Yes.
Your Lordship, I'll keep my arguments restricted to the point that this is a pure question of law, my Lords, whether a sales
Madam,
certificate.
pardon, I could not follow. Sorry.
Lords, I will keep my point restricted to only the question of law, my Lords. The point of law, what here is that after sales certificate has been issued under SURFACE Act, whether it is that the document is to be liable to be registered or not, my Lords. There are judgments of Honorable Supreme Court and this Honorable Court which says that once sales certificate has been issued and I have derived my title by the way of
to be registered.
my Lords, it
Has to
has
be
not to be registered. It can be directly muted, my Lords.
Who is the opposite party?
My Lords, we have represented Tahsildar, my Lords. My Lords, may kindly peruse the judgment of this Honorable
So
Supreme Court.
here registration has been denied.
My Lords, they are sitting over the matter. They are neither registering.
Sitting over the matter means have you applied for registration?
My Lords, according to what the point of law says that we do not require registration at all. We can directly move for mutation, my Lords. That is my only humble submission. I will place before your Lordship two
Then you
judgments.
move, who prevents you?
My Lords, the point being is that if we approach the Tahsildar to provide us means to keep the records that the record has been provided to Tahsildar to ensure that the mutation and the ROR has been carried out. We have been representing him because Tahsildar is the one who will mutate the land. So he has to follow the procedure, my Lords.
Where is your application?
Annexure 6, my Lords.
Page.
That's a pleader notice.
This is a pleader notice. I do not deny to it, my Lords.
Therefore, approach under the mutation manual. What is there? Or OSS.
My Lords, may
Law is already set.
34 is very clear. Rule 34 is very clear.
Withdraw. Yes, approach under.
My Lords, may kindly peruse this judgment. There is a.
Sorry, no. You want to route the case through High Court. This is not permissible.
Only because the sale certificate was issued way back in.
Not maintainable. We should to find out appropriate remedy.
Because the sales certificate was issued way back in 2014. Now it's 2023.
At this stage.
Then your Lordship may say that my representation may be considered that the notice.
Representation cannot be considered. Why don't you come in appropriate form? And representation pleader notice. Where is the scope of pleader notice in these cases? Pleader notice, what for pleader notice is served? Under what provision of law?
Yes, I got your point.
What? Under what provision of law?
I'm not aware, my Lords. I'm not aware.
Why have you not ventured?
Lords, I got the point that
Read
your Lordship
section
is.
80. Pleader notice intention to go for a civil dispute.
What falls for your Lordship, I got it. What falls for your Lordship.
All right.
I'm grateful. My Lords.
Item 8.
Item number 8, the petitioner is challenging the action of the opposite party number 3 for not issuing the corrected ROR matter. In the last
The entire record has been seized by CBI. That is my instruction.
Instruction. You file affidavit.
Yes.
You file affidavit. Achi, this is rolling on. Then why are you pursuing this? If it is property already attached by CBI in a proceeding, criminal proceeding, you can go very well to that court and free the property. Read petition cannot help you.
Copy of the affidavit be served to us, my lord.
Huh?
Copy of the affidavit.
To quiet, they are making a statement. I record that.
I can produce that. my lord.
Yes.
I'm producing that. Your lordship.
So you withdraw this, approach the criminal court of law that this is a property illegally attached. Free.
Second page. Election 3 paragraph.
Is the, on the earlier occasion, State Council was directed to take instruction in the matter on the issue of completion of a mutation proceeding, production of instruction, memo, addressed to Advocate General Office, Cuttack, dated 12/7/23. There has been clear indication of property involved herein being attached by the CBI involving criminal proceeding. In the circumstance, this court find no writ of mandamus can be issued at this stage of the matter. If the petitioner is so advised, may appropriate the competent court of law for release of the property before applying for the mutation, if any. With this observation, the writ petition stand disposed. Very good.
Obliged.
Item 9.
May I please your lordship? Basing upon a will nama.
ଦେଇଛନ୍ତି କପି ଦେଇଛନ୍ତି
Again.
କପି ଦେଇଛନ୍ତି
ନା ନା ଏଇଟା ଆମକୁ ଆଡ୍ରେସ ହେଇଥିଲା କୋଉଟା item 9.
Nine.
Yes, copy that.
Item 10.
My mutation appeal is rejected on the ground of limitation only. The copy I received on 14/3/2000.
What happened to your appeal?
My appeal is accordingly.
Appeal has been dismissed on ground of limitation.
Limitation.
Page 66.
Page 66.
What was the delay?
My delay, copy received on 14/3/22, appeal filed on 16/4/22.
So what was the delay?
So delay means, my lord, the impugned order 25/6/18, 3 years, 10 months. So
Is it
it
not
was
sufficient?
My lord,
Is it not sufficient delay?
my lord.
Revisable order, my lord. Under rule 42A,
Limitation
it can be revised, my lord.
limitation रे dismiss कले revision को कहीं जाने जीवो. So let us issue notice other side आसंदु किसी cost देवे restore करी appeal की hearing पे पठेगा कौन से revision रे कौन और consider से करे. Merit cannot be gone into.
Yes.
Yes, impugned order appears to be rejecting a miscellaneous appeal, mutation appeal under the provisions of OSS Act and read together with mutation manual solely on the ground of limitation. This court feels considering there is private party involved. Private party achanti? Private party is involved through OP number 6 and 7. This court feels it appropriate to issue notice to the parties. Notice accordingly. Registry requisites be filed by tomorrow. Say the requisites and service of copy. Both by tomorrow. Registry directed to issue notice on OP number 6 and 7, fixing short returnable date. Matter may be placed immediately after appearance of OP number 5 and 6.
Item 11.
My lord, because I am for the petitioner, my lord. Lord, I am challenging.
This is a miscase under what provision of law?
My lord?
Miscase you are pending. Miscase is under what provision of law? Correction of record of right.
Correction of record of right, my lord.
But following a read court direction.
Yes, my lord.
Where is that read court direction?
Answer 2, my lord.
Annexure 2 page koibe. Annexure 2 koile page koibe.
Page 19, my lord.
Page 19,
my lord.
No, 19 page. It's
Opinion 2, my lord.
Start of cause title, but the read petition is dismissed for non-prosecution.
Non-prosecution, my lord. Opinion 2 goes to court, my lord.
Huh?
Opinion 2, my lord.
No, opinion number 2, Corona. Yes, you give a lawful disposal this application.
Yes.
Prayer court the annexure force in spending on sanction issue. This court direct the Tahsildar Kontapada OP number so and so to give a lawful disclosure to the petition brought in by the petitioner. However, involving party likely to be affected, if any. Let the entire exercise be over within a period of 3 months of the date of communication of order along with a copy of it. Same order in the other case also.
Yes.
Mm.
Item 12,
Yes. 12 ସେଇ ଓକିଲ କି?
ନା ନା 12 ରେ
ସେମ୍ ଓକିଲ ପଳେଇଗଲେ ସେ ଅଶୋକ ମହାନ୍ତି ଏଟା ସେ
ନା ଏଟା ଆରଟା ଅଶ୍ୱିନୀ ମହାନ୍ତି
ଅଲଗା। ଓକେ ଏଥିରେ କଣ ଅଛି ରିପେଣ୍ଟେସନ NS1 what is that representation? ଓକେ ବସୁନ୍ଧରା ଯୋଜନା
ବସୁନ୍ଧରାରେ ଜମି
self same issue NS1 is pending before OP number so and so Tahsildar Cuttack Sadar who is directed to give a lawful disclosure to the application herein, also keeping in view the grounds stated in the writ application by giving an outcome within a period of 3 months. Yes, the non-appears next also same.
item 13,
May I please?
Yes.
Your mother, the petitioner.
What is this application? Porsinga Gram Panchayat Sarpanchayat Purvatana Swami
Trying to construct a market complex
market complex କରୁଛନ୍ତି
in front of my house.
Tahsildar has he given any decision? କିଏ decide କରିବ? Better collector କରନ୍ତୁ.
Yes.
Collector copy ଦେଇଛନ୍ତି? Yes. On the self same issue it appears the complaint herein pending consideration of the collector Bhadrak.
Yes, I have given collector. I have given collector.
You will give. You file a fresh complaint.
No. I have already filed.
Yes, that is appearing at page 16.
Yes, ma'am.
So, all right. As clearly appearing from page 16 of the brief. In the event the collector of the district is in receipt of such complaint, same may be given a lawful disposal, however, involving parties likely to be affected. If necessary, entering into appropriate inquiry in the involvement of the parties, giving lawful disposal at least within a period of 2 months, considering urgency involved in the matter.
Till then, my lord, no construction. Till then, no.
Provided there is no construction.
No, yes, my lord.
Nature of construction already commenced. The commencement of construction may await for a period of 2 months.
item 14,
14 for disposal of the OSS case number 1378 of 2022 pending before the Northern Divisional.
Has it been admitted?
Yes, madam.
Yes,
Admitted
in this case already report called for. Report was already called for. Now case is posting for final disposal.
Which date?
Date
in the month of November, my lord, date actual date
However, they might be going serially. Upon keep data expedite hearing
November
matter.
Let also direct the Tahsildar Talcher may submit a report, my lord.
So report may be ensured before date of hearing, next date of hearing. That can be.
They have not fixed the date of hearing because the report has not come, my lord.
Okay,
I have gone twice.
At the submission of Sri Mahanti as well as Sri Ponda. Read petition involves a serious allegation on the delayed disposal of the OSS case number 1378 of 2022 for non-submission of the report of the Tahsildar
Talcher, my lord.
Talcher already called for by the competent authority. This court considering the submission direct in the wait. The report of the Tahsildar Talcher in the proceeding involved is yet to be received. The competent authority shall ensure in receiving such report at least within a period of 2 months, 1.5 months, and giving a lawful disposal to the proceeding within 2 months thereafter.
Obliged.
But in the involvement of the party likely to be affected. Yes.
item 15,
Item 15, my lord, I may be accommodated on VC, my lord.
Yes.
Here, my lord, Annexure 6, page 22 is the
Yes.
order passed by the municipality cancelling my allotment on the ground that I have made the foreign structure which is not correct at all. Under annexure,
On the premises,
that I have made the foreign structure over the same.
permanent to କହୁନାହାନ୍ତି asbestos କିମ୍ବା ଟିଣ ଛାଉଣି କରି ଦୋକାନ ଘର ତିଆରି କରିଛନ୍ତି।
ଆମେ ସେୟା କରୁଛୁ ଟିଣ ଛାଉଣି ମାନେ କରିଛୁ ଆମର ଷ୍ଟିଲ ଆଲୁମିନିୟମ ଦୋକାନ।
Where is the allotment order?
Annexure 1, my lord. Annexure 1, page 15. That is also one of the clause under paragraph 4 that if in place of
you have been allotted with a plot only.
Space, yes, my plot only.
Right, space for having your business.
Yes, ma'am.
So how have you put up it?
I made an application under annexure 2. I made an application.
Condition 4, page 15.
Yes, madam. Condition 4.
Please read.
The license holder will place a cabin on the space for the purpose of shop. He shall not deliver possession or
how
sublet
could you raise the construction there? So you have violated the license condition.
With the permission, I can, my lord.
So where is that permission?
There, my lord. If the license you want to raise a temporary structure
Where
on the
is the
space,
permission? Show me.
Annexure 2, my lord, my application in 2019. Your lords, we have a glance. Next page, page 16.
For?
Allow me to temporary that lordship may turn to page 16.
Where is order allowing it?
No, they have not allowed. Only, my lord, they cause an inquiry. They cause an inquiry. My lord, I have specifically stated they cause an inquiry.
Admittedly, you have undertaken a construction.
Construction, my lord, only asbestos. My so-called notice reply, page 21.
Lenka, you can't violate.
No, my lord, I have not violated the same, my lord.
You should have waited for the permission.
Your lordship may
No,
turn to page 21.
We can't legalize the violation of the conditions in a...
Your lordship may turn to page 21, my lord. My so-called reply, where I have specifically mentioned that with the permission, I have put a asbestos roof only, no permanent structure.
Cannot be there without permission.
So that application itself, my lord, your lordship, annexure 2 is my application.
Filing an application doesn't establish that is granted.
My lord, they allow me. With their knowledge, I constructed. Well, they caused the inquiry. The spot visit was there.
Correction for consideration. Sorry.
But Annexure 7, page 23, Annexure 7 is pending before them, my lord.
It can't be considered. I can't. If they give a result, that's a different thing. But I can't give a direction.
Because unless, my lord, they'll demolish the structure. That is the.
Obviously. Why don't you approach them to take out the construction and to put a cabin?
The Annexure 7, my lord, I have made a request. After that order was passed, I have submitted a petition.
That para, where have you assured that you will take out the construction?
My lord, the page,
your time and my time, Mr. Lenka.
No, page 24, it is therefore paid your. You can kindly withdraw the notice.
Sorry.
That 19/6/2023 and pass order to renew my license and receive the license.
You want withdrawal of that cancellation order, not taking out your construction. This what do you want? You will withdraw or I'll dismiss.
Without liberty to approach the authority.
No, I will not give you any liberty. You are a violator of license.
Some order may be passed, my lord, is a one person, my lord, earning the livelihood by running that shop, my lord.
To threadbare argument. And on perusal of the, you may withdraw simply, otherwise you are taking observation to only affect.
No, withdraw.
Which now wants to withdraw the writ application and doesn't want to pursue litigation here. Yes.
Item 16.
16, may I please, your lordship? Lordship, there is a limited prayer before your lordship for a direction to dispose of the OLR miss case.
It is for fresh admission.
Pardon, my lord?
Matter has not been admitted as of now.
No, it has been admitted. The report has been come from the Tahsildar. Everything is done. That is only for disposal. pending for disposal.
It is pending for disposal, pleadings completed. you
Yes,
say.
yes.
All right.
Kindly see Annexure 6.
Yes, case is put up today. The report of the Tahsildar has been received and attached. So why is not completing the proceeding? Thereafter, so many adjournments.
No, Euler miscase dropped.
Drop is finally.
Yes, page 40.
On perusal of documents and report, it is found that the sum of the case land is Gharabari, which is neither an agricultural land. Yes, it is dropped finally.
No, Lordship, it is an order in another case. In a similar matter, it has been disposed of.
Similar
It,
matter.
yes.
Then
my case is.
what is your proceeding? 25 of 23.
Yes, it is my case is 25 of 23. It is in the case of 118 of 22.
Oh, you have given a output in similar matter.
Yes, Your Lordship.
It is counsel for the petitioner submits involving Wheeler miscase 25 of 23, not only pleading got completed by this time, but there is also submission of report, desired report from the Tahsildar. Okay, the state council submits in such event. There is no hesitation in this, giving a lawful outcome to the proceeding involved. Okay, considering the rival contention, this court observes in the event. Reading in Wheeler miscase 25 of 23 already got completed, and desired report is already received. Steps as appropriate for giving a lawful outcome to such proceeding be given at least within a period of 3 months from the date of communication of problem. However, involving parties likely to be affected.
Obvious.
Item 17.
May I please, Your Lordship? The petitioner in this case begs to challenge the inaction of the opposite party number 1, not allowing for filing of the consideration appeal case of the petitioner. In a
Not
plea,
filing means you went there and on your extending the appeal memo, he refused to
already
receive it.
refused, not allowing that there is in a plea.
So not allowing ମାନେ କଣ? ନାଇଁ
ସେ-
ଆପଣ ଦେଇଦେଲେ ସେ allow କରିଦବ.
ନାଇଁ ନାଇଁ ଆମେ ତାଙ୍କୁ ଦେଲୁ ଫାଇଲିଂ କରି କହିଲେ ଆମେ ଫାଇଲିଂ କରିପାରିବୁ।
Not receiving or not allowing କଣ କହୁଛି? He is not accepting your application even.
Yes,
Is
madam.
that your contention?
Yes, madam.
Yes. Then he is not accepting. Then why did you not send through registered post?
I'm going to meet
That is also a forum. Now e-filing is also a forum. You don't take any further endeavor.
I meet the concerned authority, but they refuse that there is no staff.
The serious accusation against the Joint Director of Consultation, Range 1 Qatar, even not receiving the appeal memorandum submitted by the wanted to be submitted by the petitioner for the without entering into such controversy, this court disposed the writ application. Observing in the event petitioner retenders the appeal memorandum in original to the competent authority, same shall be accepted, registered, and will be given a lawful disposal after involving parties concerned.
Sir, delay may kindly be condoned. Delay may kindly be condoned. Delay.
Delay କାହିଁ ସେ ତ ଏପର୍ଯ୍ୟନ୍ତ ରିସିଭ୍ କରିନାହାନ୍ତି। Delay ହେଇଯିବନି appeal ର କେତେ ଦିନ?
Delay ହେଇଛି sir.
Okay. ସେଇଥିପାଇଁ ଆପଣ ରେଜିଷ୍ଟରରେ ପଠେଇ ଦବାର ଥିଲା। Who will believe now? ଆପଣ ଡିଲେ ହେଇଗଲେ ଏଠି ପଳେଇ ଆସିଲେ ଫାଇଲ କରିଦେଲେ ରିଟ୍ ପିଟିସନ ଆଜ୍ଞା ମୁଁ ଗଲି ମତେ ଦୁଆରୁ ଫେରେଇ ଦେଲେ। Who will believe you?
ନା sir, ସେ ଫେରେଇ ତ ଦେଲେ ସତ ସାର୍, କିନ୍ତୁ ସେ କଲେନି, ମନା
ଆପଣ
କଲେ।
ଯେମିତି ମନ ଦୁଃଖ କରି କହୁଛନ୍ତି ଆପଣ ନିଜେ କ୍ଲାଏଣ୍ଟ।
On behalf of the client, my lord.
ଦେଖନ୍ତୁ ଭିସିରେ କେମିତି ଦେଖଉଛି ଆପଣ ଏମିତି ମୁହଁଟାକୁ କରିଦେଲେଣି ଯେ ସତେ ଯେମିତି ଆପଣ ହିଁ ଯାଇଥିଲେ ଦବା ପାଇଁ। ଆପଣ ଯାଇଥିଲେ ଦବାକୁ? କାହାଣୀ ଆମେ କରିପାରିବାନି। ତେଣୁ ରେଜିଷ୍ଟର ଫେରିବେ ସେଇଠି ପାଖରେ ଯୋଉ ପୋଷ୍ଟ ଅଫିସ ଥିବ ସେଇଠୁ ପଠେଇବେ। ଆପଣଙ୍କର ଅଫିସରେ ମନା କରିଦେଲେ ତେଣୁ Okay, ଲେଖା this court further observes in the event there is delay the appeal memorandum being accompanied with a delay condonation application. The delay shall be condoned, but however, after involving the parties likely to be affected. And the appeal memorandum will be given a lawful disposal. Please be careful hereafter.
Yes.
Item 18.
May please, your lordship. Here,
Early
my-
disposal, this appeal has been admitted.
No, my lord, the annexure to RMC that has been remanded for fresh adjudication. Since
it-
2003, it is the pending before the
So
sub-collector.
appeal is reopened on remand.
Appeal is not appeal, my lord. The
Original
object-
proceeding.
Original proceeding. And notice has been issued to all
When it was remanded?
remanded in the on the 8th August 2003.
2003.
3.
What are you doing as of now?
And the RMC case number is also 3 of 2003. My lord. Till then, for last 20 years, it is pending. And the pleadings is over. All the opposite
It
party
is
have taken
pending
notice.
only for 20 years.
Yes, my lord.
What is the date of notice annexure to?
This is on 5/4/2022. 5/4/2022.
In this proceeding itself, and thereafter there is no development.
No development, my lord.
It is
And my
strange to
instruction is
observe.
that the case is fixed to 2nd
Okay, all
August.
right, it is strange to observe in the original proceeding, RMC 3 of 23 reopened after the remand order in the consultation appeal 3 of 23. What is the number of original proceeding?
Original proceeding number, my lord, that is 8 of objection case number 581 of 8. The
81
oblique
of
8.
8.
That is page number 11, last line, my lord. Annexure 1, page number 11, last line.
Okay, sorry. Original proceeding 681/8. After being remanded on the basis of order passed in consultation appeal case number 3/2003 is kept pending since 2003. Through annexure 2, it has been brought to the notice of the court that in the meantime, there has been notice to parties involved therein for hearing of the matter on 21/4/2022. However, there is no further progress considering unnecessary long pendency of the proceeding involved. This court direct the competent authority to give a lawful disposal to the proceeding in the involvement of parties likely to be affected at least within a period of 4 months. Please come to page 15.
My lord.
ये तारीख को किए लिखला?
So, ତାଙ୍କରି ଲେଖା।
हाँ?
ତାଙ୍କରି ଲେଖା।
ତାଙ୍କର ଲେଖା ଆପଣ ପା ଏଠି ହାତ ଲେଖିଛନ୍ତି?
ଆଚ୍ଛା ଦେଖାଯାଉନଥିଲା ଖାଲି ଇଏ କରାଯାଇଛି।
କଣ ଲେଖିଛନ୍ତି ଦେଖିଛନ୍ତି ଆପଣ କପିରେ? ମସିହାଟା କଣ ଲେଖିଛନ୍ତି ଦେଖିଲେ?
21/4/20/22।
20/20/22 ଗୋଟେ ଅଛି?
ନାଇଁ ସେଟା ତାଙ୍କ ଟାଇପ କଲାଟା।
ତାଙ୍କ ଟାଇପ କେମିତି ହବ? ମୁଁ ଆପଣଙ୍କ ହାତରେ ଲେଖିବି।
ନାଇଁ next date is fixed to 2nd August, my lord. My instruction is that after this filing of the case, we have informed the sub-collector. He has fixed the date to 2nd August 2023 for hearing.
ଯଦି କରିଛି ଆଉ କାଇଁ ପରସୁ କରୁଛନ୍ତି?
ସେ date ରେ କରିଦିଅନ୍ତୁ ସେ dispose।
କାଟି ଦିଅନ୍ତୁ। ନାଇଁ ସେ date ରେ ଶୁଣନ୍ତୁ। It is to be seen whether all parties have come or not. Preferably within a period.
Well, within a period of
then you should not have pursued. ସେ ଯଦି ଏଇଠି hardly ଆଉ 10 ଦିନ ପରେ କେସ୍ ଅଛି ଆପଣ ପରସୁ କାହିଁ କରୁଛନ୍ତି?
ଆଜି ସକାଳେ ମୁଁ ତାଙ୍କୁ
ଆଜି
instruction
ସକାଳେ ହେଲେ ଆପଣଙ୍କ best course should have been you should have simply withdrawn, sir. The date is already fixed. I may go away. ଆର୍ଗୁ କରିଦେଲେ ପୁରା ତାପରେ ଡାକି ସାରିଲା ପରେ କହୁଛନ୍ତି ଆଜ୍ଞା ଡେଟ୍ ଫିକ୍ସ ହେଇଛି।
ସେ date ନ କଲେ ପୁଣି ଅସୁବିଧା ହେଇଯିବ।
Yes, next.
Item 19.
Lordships.
Yes, Mr. Patnaik.
The petitioner has filed this application challenging the action of the authorities, that is annexure 5 and 6, where the authority, as per the annexure 1, my lord, the government decided that all work should be handed over to the Panchayat department, including the school and mass department's works, my lord. After accordingly, annexure 2, my lord, the principal secretary to government, PR department, they instructed the, requested the principal secretary government to school and mass department to make an arrangement for transfer the assets. And thereafter, an agreement was executed between the school and mass department and the panchayat department. And accordingly, last time see that page 19, a categorized page which work will be done by the panchayat,
What
and
happened
this
to annexure 9?
blood annexure 9.
Any development?
Yes, no, that is my representation. No, now they are going to execute the work by the Panchayat Samiti and Jila Parishad, where the Panchayat, who is the important organization, has been ignored.
Who are you?
I have the Sarpanch of the Panchayat. I am Sarpanch of the Panchayat.
No, you are not. You are not coming to court as Sarpanch. You are coming to court in individual capacity.
At present, continuous Sarpanch of the Gram Panchayat.
Oh, you are Sarpanch. That is understandable. But who has come to High Court? Who has come to High Court?
Person concerned.
Sarpanch or person concerned?
Represented through.
Correct your cost. Place the matter tomorrow.
Yes.
The Patna Learned Council is permitted to
Yes,
make
yes.
necessary correction in the cost title. Also incorporating such correction in the copy supplied to Government Council.
My lord.
Item 20.
20, my lord, in this case, I have a limited grievance that the order passed by the RDC dated 20/12/2021, my lord, it has not been carried out by the Tahsildar as on today, my lord.
Has not been worked out.
No, my lord.
This annexure 2.
Annexure 2, my lord.
15B, there is direction for correction.
Yes, correction of ROR.
Okay, there is no further challenge.
No, my lord, there is no further.
At the submission of Land Council and the State Council. Repetition involve allegation of not working out the direction of the competent authority in a section 15B OS and S Act proceeding involving RP 189 of 19 passed on 20/12/21. This court, considering the grievance here observed in the event, there is no deviation to the order at annexure 2. The same should be worked out without any further delay. Let the competent authority bring out appropriate record of right in terms of annexure 2, but while also keeping in view the observation herein above, the entire working may be completed at least within a period of 1.5 months from the date of communication of order. Free copy of order is
obliged.
Item 21.
May I please, your lord. Under annexure 1, my lord, at page 9,
What
13.
happened to annexure 6?
Yes, my lord.
It is pending.
Pending, my lord.
On the self-same issue, it appears request on behalf of the petitioner by annexure 6 is pending before Executive Officer, Puri Municipality, OP number so and so. In such event, the OP number so and so is directed to give a lawful disposal to annexure 6 while also keeping in view the request of the grounds taken in the writ application as well as the documents taken support herein. By giving a lawful disposal within a period of 2 months from the date of communication of order. Secondary query was
Annexure
same
10.
order but annexure 10.
Annexure.
Item 22.
My lord, item 22 kindly taken up next week.
Next week. All right, council wants adjournment of
Okay.
the matter, place the matter 1 week after date for down.
Item 23.
Again, 23, say prayer for a direction to the opposite party number 3 for issuance of ROR on the basis of mutation application filed by the present petitioner.
On receipt of?
On the basis of a mutation application filed by the present petitioner, my lord.
Mutation case number, what is the case number?
Mutation case number 19,505/2023. Annexure 4 have a glass, that is the acknowledgement receipt of the mutation application.
Then that has been allowed.
Yes, my lord. The tentative delivery date was given 14/7/2023.
Through the petition, petitioner, while also taking this court to annexure development, where annexure 4 submits in spite of a mutation case being allowed. Bracket a mutation case 19505 of 23 being allowed. There is no bringing out of the corrected record of right. This court observed in the event the mutation case 19505 of 23 has been given a lawful disposal and there has been no further challenge to same. There should not be any delay or obstruction in bringing out a corrected cause, a corrected record of right. Okay, this court thus direct the Tahsildar Bhubaneswar to bring out corrected record of right at least within a period of 1.5 months from the date of communication of order, along with copy of it. Yeah.
Item 24.
May I please, your lordship, in this case, the petitioner challenged the order of the Lokayukta, wherein the Lokayukta during pendency of the proceeding directed for initiation of departmental proceedings.
Similar matter has been admitted.
Admitted and no corrective action is directed. Is pending.
But these are vacation orders.
That is vacation, but that this is
Vacation,
pending.
normally we give interim order. There were days when one of the excellent judge used to rise in 1 minute after finishing 100 cases. All cases issue notice stay.
The merit also, my lord.
So vacation stay cannot bind the non-vacation.
I am not submitting that. The proceeding.
All right, take it. Simple. If disparity is my client will slap me if same order is not coming.
Statute prohibit করছি
ଆଉ କଣ କରାଯିବ ସେ ତ କରିଛନ୍ତି ଗୋଟେ ଆଉ ତାଙ୍କୁ ଯଦି ନ ଦେବି ସେ କହିବ ନା ଆପଣ ପାରିଲା ଓକିଲ ନୁହନ୍ତି ମୁଁ ସେ ଓକିଲ ଦେଇଥିଲେ ଭଲ ହେଇଥାନ୍ତା. Yes, next.
May item 25.
କଣ ଏ fast contempt?
Fast contempt, may I permitted to read the order, your lordship?
Yes, read କହୁଛନ୍ତି କଣ କରିଛନ୍ତି ବୋଲି?
Let him read, my lord. Let
Okay,
him.
all right. What was the direction?
Paragraph 3, your lordship. Though the entire order sheet at Annex 5 involving the proceeding, it is established that whenever the case.
High Court order ପଢୁଛନ୍ତି ତ?
My lord. Running page 9.
Paragraph?
Page 9, paragraph 3.
Para 3.
My lord.
Yes.
Though the entire order sheet at Annex 5
ଏ mic ଟା down କରନ୍ତୁ.
ଆଉ ଟିକେ ତଳକୁ କର.
ଆଉ ଟିକେ ତଳକୁ କର.
ଆଉ ଟିକେ ତଳକୁ କର.
Though the entire order sheet at Annex 5 involving the proceeding, it is established that whenever the case is posted, it is adjourned finding the competent officer BG otherwise. The order sheet up to 13/8/2021 shows that the officer was busy in COVID pandemic issue. Then in September 2021, the officer became busy due to fraud related work.
This was order passed when? 6/12? 6/1/23.
6/1/23.
But thereafter the case is taken up. Now after this court direction case is taken up on 14/2, advocate for appellant has filed a time petition. You filed a time
for 1 month time.
Then on date of hearing 21/4/23, appellant has changed his counsel. Why are you pursuing such litigation? Throw this application. Your party is playing now. And you started arguing. So you will continue or I will make observation.
First, your lordship direction.
Any order?
Your lordship.
Huh?
Your lordship.
You say any order? Or a justified order?
Justified order.
Any order?
Your lordship. First contempt.
Yes, even though a contempt has been brought, taking cue from the order of this court in dated 6/1/2023 in WPC 36567 of 2022, giving direction, time target to the competent authority for completing the proceeding. Today in the course of hearing, Sri Ponda, learned Ponda, counsel appearing for the contemner produces instruction memo of the sub-collector Bhadrak which discloses after the High Court direction, the proceeding has been taken on 3 occasions. In the first occasion on 14/2/23, advocate for appellant filed a time petition seeking 1 month adjournment. On the next date of posting 21/4/23, appellant himself changed the earlier counsel and consequential adjournment was sought for. On the next date of posting 1/6/23 to 28/6/23, next date of posting, there was pen down strike called by the district level combined ministerial association all over Odisha. This court finds there is genuine difficulty in not disposing the proceeding in strict terms of the direction disposal in WPC 36567 of 2022. However, since the proceeding requires timely disposal, this court, while restricting the appellant from seeking any further adjournment, direct the appellate authority to conclude the appeal proceeding at least within a period of 1 month from the date of production of order by the counsel of the contender or the appellant or the petitioner, whosoever. Yes. It's a free copy diabani. You have to take a certified copy. Content proceeding does stand raw. Like ये छिड़ा ହେଲା ମାନେ ମୁଁ ଭାବୁଛି ସେ କନିସି ତହସିଲଦାର କି ଏଇଟା କନିସି ନୁହଁ ତ
ବନ୍ଦ ହେଇଯାଇଛି ବର୍ତ୍ତମାନ ଆସୁ ଆମେ ଗୋଟେ ଆଫିଡେଭିଟ ଦବୁ
ଦେବେ okay see Pondar and the council have
10 days after your lordship may call next Friday
have the instruction to appear for contemner. Let 1 copy be served on Sri Pondar. Okay, place this matter 28th Rasu.
Yes, yes.
Place this matter on 28th affidavit and or objection, if any, by the contemner.
Yes.
Should be filed before that date, before the next date of posting.
Yes, madam.
For order item 27.
May I please, your lordship?
Yeah.
Here the petitioner initially, this is a disposed of matter, your lordship. Initially, the petitioner has challenged.
Pardon?
This matter was a disposed of matter, your lordship.
Disposed matter, then in the miscellaneous proceeding, notice was issued.
Yes, I have filed an application
for
clarification, your lordship. They are saying this writ petition is still pending, for which they are not revoking the cancellation order that was passed against me since 2012, for which I am not unable to operate the unit. Your lordship, I have annexed their letter. That is page 35.
What was the read court direction?
Read court direction was for a joint inquiry, and I have quoted the direction, your lordship, at page 3, your lordship.
Read past the last para.
Yes.
Be that as it may.
May this court, taking into account the response of the petitioner that the petitioner is taking sincere steps to run the unit as before, and in absence of any material as to whether the establishment has any recommenced, this court, while keeping in abeyance the order at annexure 4 for 1 month, direct the opposite party to have a joint spot inquiry to find out whether there is a recommencement of the establishment involved herein, involving the petitioner, and the authority pass appropriate orders in the matter.
Therefore, now what have they done?
They have called me. I have deposited the amount, so tuning to rupees 14 lakhs some odd.
What is the ultimate outcome?
Now at the last and page 35, your lordship may kindly see. Page 35 of the miss case.
You are appearing for the contesting party?
Yes, your lordship, for INCO.
Yes. Yes, page 35.
Remarks, your lordship may kindly, middle portion, remarks.
Yes.
The proposal relates to revocation of cancellation of allotment, that you have filed WPC number such and such, the present WPC.
Yes, why your client is writing this? The read petition is already disposed.
Yes, sir.
So you recall this.
Lordship, I have taken instructions. His IA may be allowed.
at the submission of the respective councils on the IA 3484 of 23. Impugning Annexure 12. A correspondence of the competent authority dated तारीख को कौन पढ़ती कुछ नहीं okay under reference 2022/10/042 counsel for the petitioner contends there has been misunderstanding of the final order of this court and the issue involved therein is unnecessarily kept pending on the guise of pendency of the writ application 1192 of 2012. After considering the submission of counsels appearing for respective side, this court finds the writ petition WPC 11192 of 12 was disposed of with the following observation. Be that as it may, last process of law. Okay. It is in this circumstance this court finds there has been wrong reading of the direction of this court in the aforesaid writ petition, and as a consequence, Annexure 212 is a wrong communication. This court, while disposing the IA, direct the competent authority to remain abided by the ultimate direction in the disposal of WPC 11192 of 2022, since finally disposed, and to give outcome in terms of such direction, at least within a period of 1.5 months from the date of communication of order.
Obliged.
Obliged, Lord.
Yes, next is withdrawal.
My lord, already filed.
Constitutional matters and dismissal return.
Item 29.
Yes, 29. Yes, Harku. You are the review petitioner.
Lordship.
You are the review petitioner.
Yeah, I am the review petition.
Okay. What was the judgment?
Lordship is given the judgment is in my review petition, the annexure number 2, my lord. Copy of the page number 12.
Page 14.
Page 12, 14, my lord. The order, exact order starts from 14.
Yes, page 14. What was the direction finally? See, oh, yes, that proceeding was dropped. That proceeding was dropped as it is no more entertainable.
Yes, my lord.
No. Shoot, in this case,
Just please be on mic. Please be on mic.
there are two CMP applications. The application one is 151, other one Order 7 Rule 11. And this order dated this 10/3/22. This CMP is 861. This arises out of 151 application.
One was 151, other was Order 7 Rule
11. That your lordship kindly see in paragraph.
Coming to you, Mr. Counsel. Just
Yes.
I'm coming to you.
I'm sorry.
So there your lordship kindly see, your lordship has already in para 3 and 4 has stated with regard to that CMP application, this CMP. And here
you say this CMP 861.
Yes. Relates to section 151 application.
Section 151 application.
Yes.
And what is the ultimate direction?
Ultimate direction is that suit is, kindly see,
Suit no more continue.
Yes. Milord, that if any direct civil suit treated to dismissed as no more entertainable.
Okay, now let him continue. Now
Milord.
let him continue.
So Milord, here Milord, other application with regard to 711.
That I understand. You
Yes.
say there is no 711 involved here. Therefore, he was possibly last date he was taking the stand.
Yes.
711 cannot be entertained in a CMP.
That is Milord.
That is his submission. That is his submission.
Milord, that is what Milord, he is thinking that this order relates to 711.
Also 711.
Yes.
So let us see what was the SLP. Let him argue. Let him argue.
May I please, Lordship?
Yes, now you continue. You
Lordship,
went to Supreme Court against this
yes,
order.
my lord. Against this order, we went to Supreme Court, SLP, my lord.
Then what the Supreme Court
SLP
did?
order is there, your lordship, at page number. In the same book.
Page 11 probably.
Yes, my lord. Page number at
11 probably.
yes,
Annex
my lord.
1.
Yes, my lord. 11. A landed counsel appearing for the petitioner seeks permission to
No,
withdraw.
before that, just see at the top. See at the top, after the special leave petition, arising out of
One application
arising out of
an IA.
final judgment in so and so CMP 861 of 16.
Yes, my lord. One
So therefore,
application.
this was arising out of 861.
861.
Yes. Now, what is the direction? Please.
Your
read.
lordship.
No, my lord,
Without
before-
expulse.
Milord, I'll just interrupt.
Lordship,
Before
sir.
since your lordship has already put a question with regard to what is the SLP. In the SLP, they have stated with regard to Order 7, Rule 11.
You're challenging the.
SLP is, last time I had asked for.
Yes,
SLP.
my lord, your lordship kindly see, they have served me a copy. I have not. If your lordship kindly see in
This SLP is 19252.
Yes.
Yes, they have given a copy here.
Yes, they have given me a copy also.
Then
So
SLP.
your lordship kindly see synopsis list of dates, that is B.
Page B.
Page B. B for Bombay.
B for Bombay. Yes.
Your lordship kindly come to Millard. The trial court here, your lordship kindly see the petitioner plaintiff filed CS number 2 of 16 in the court of civil judge Banai for permanent injunction restraining defendant 2 to 10 or their or servant anybody claiming through them or under their in any way acting as a managing director Banai Industrial Company, defendant number 1. Thereafter, the defendant number 1 filed Order 7 Rule 11 application for rejection of plaint. The trial court by detailed order rejected the said application as the ground rate or the post-trial defense. Thereafter, they filed civil miscellaneous petition in the High Court of Orissa. The single judge of the High Court erroneously reversed the order of the
But
trial
this
court
order was never involved.
and allowed the
This order was never involved.
on the ground mining lease carried out on the company as expired dismissed.
Right,
The
this
single
order
judge-
was never involved.
Never involved.
So that's your submission. Let him complete.
Yes, the single judge, kindly see, again, the single judge has failed to note that suit is for permanent injunction and expiry of mining has nothing to do with the suit. Further, the grounds passed in Order 7 Rule 11 application are post-trial defense and they can be decided only after framing the issues. Hence, the moves of this court by way of cessation petition. So, your lordship kindly, then I.
We are only pointing out.
All right, let him complete. Let him complete. In his own way, let him complete. That's that. This cannot be avoided now. This cannot be avoided. Therefore, you have misstatements in the SLP application itself. You remained all through under impression as if the High Court has taken up an issue involving Order 7 Rule 11 and taken a decision. Therefore, you went with a plea that this is writ petition not maintainable or the CMP not maintainable. But the case you have involved there, did not involve order 7 rule 11.
Yes, your lordships.
So
order
therefore, why are you pursuing this
Your
litigation?
lordships, some, it matters, some places of your lordship's judgment, referring some order 7 rule 11 also. What through
No, order
application.
7 rule 11
Your
I am
lordship,
not.
just a minute, your lordship. The order passed in 1133, your lordship, one page order. Your lordship has passed the order in 1133, order 7 rule 11 application. Your lordship may take up
Where
that
do I
order.
find? Where do I find that?
Now I got it from the net, my lord. Order 7 rule 11 order your lordship
Then
has
give
passed.
copy to them and me, both.
I'm sorry, my lord, it was been, they have been, your lordship may ask them yesterday
It
itself.
is outside the brief. No, this is another CMP.
Another CMP, order 7 rule 11. This
But that is never challenged in the SLP.
they are not, your lordship, because some orders in your lordship's order, something has been referred. Therefore, we under the impression a common order has been passed.
No, there is
No, 1 minute, my lord, 1 minute, my lord, 1 minute. Before the trial court, a common order is passed and they have filed an appeal, one CMP before this honorable court, and reserving their right under order 2, rule 2, order 2, rule 2. But without getting a reservation, they filed one appeal is CMP in 861. Subsequently, only 1133 was filed before your lordships. Then in 1133, the advocate may be taken notice. I'm not saying about it, but not yet admitted. It is continuing along with that applications. Along with this also it is coming up. The both matters has been come up. But when the orders has been passed by your lordships in these matters, that your lordships passed an order only in this case, not the other case, not with regard to the other CMP, only the order. And in the other CMP, it is unnecessary and it is dropped because in view of the orders passed in 861. Therefore, once in 861...
No, that is not the only reason.
Your lordships...
That is not the only reason. That is mere recording. First I say, in spite of appearance of a set of counsel, nobody is coming.
Yes, my lord. That's
so
correct.
Therefore, nobody was pursuing that litigation.
Agreed.
And you are Mr. Veerapatiran.
Veerabhadran, my lord. Veerabhadran.
Yes, Mr. Veerapatiran.
Yes, my lord.
Your SLP, you have now taken a leave from Supreme Court and have come back here.
Yes, my lord.
Entire SLP, though the pleading rests on Order 7, Rule 11, but it is against the order of the court in a writ petition which never touched the 711. So therefore, why are you pursuing this? You may have a remedies. Listen, this is another order.
Yes,
this is another CMP. This is a CMP maybe touching the order in this Order 7, Rule 11.
No, order 151. This is this order is
151 order you assailed in Supreme Court.
Supreme Court.
But this is the CMP you are now producing, CMP order.
Yes, my lord.
This CMP involved Order 7, Rule 11.
Order 7, Rule 11.
Therefore, you take appropriate step there. Where is the question of review here?
Your lordship, review only with regard to 151. 151 application. There are 2 applications has been filed.
Then you are other day you are arguing Order 7, Rule 11.
Both it's a combined because it is a combined order.
Okay, argue. So now things are clear.
Yes,
there are 2 CMPs.
2 CMPs.
One CMP involving 151, the other CMP involving the Order 7, Rule 11. The 151 CMP involved is a merit order, merit disposal.
Yes, my lord. Yes, my lord.
And the other CMP is a technical disposal in view of disposal of the other CMP and non-appearance. Because nobody was available to argue. So therefore, now your 151 order is you are to confine here.
Yes, my lord. 151 order I have to confine.
So what is the scope for review now? Tell.
Your lordship, now your lordship say, the question of review, now I am filing it. Your lordship knows about it. Our High Court, this High Court judgment, division bench judgment. If an advocate has not been appeared and an order has been passed, then it can be review can be filed and review can be allowed if a bona fide things has been happens.
Sorry, I could not follow. What is your submission?
That is one judgment of our High Court, this High Court, my lord.
That was the CMP decided In your absence,
Yes, my lord, in my absence.
you did not appear.
I have not appeared.
In
Same
spite
thing
of-
happens here also.
In spite of notice, you did not appear.
Yes, originally I
Yes,
appeared.
nobody appears at the time of call.
Fall. Originally I appeared and I argued number of occasions. I can read the last paragraph, your lordship. Para number 10 at page 354. The perusal of the record of the OJC number 13273 of 2001 would show that the review petitioner had appeared through his lawyer by filing Wakalatnama on 18/6/2002. Once a person engages a lawyer, he naturally remains under the impression that his case would
Therefore,
be...
the person should not suffer.
Yes, my lord. Yes,
The
my lord. The
proposition is
party
person
should not suffer
suffer.
because of the absence of the advocate counsel. In my case, what had happened, my lord, we have given a wakalat for one advocate as an additional advocate of this High Court because we are coming from Chennai. Therefore, that advocate has been changed and another change of wakalat has been filed. But the change of wakalat, the name has not been mentioned, but the earlier advocate name has been mentioned. It has not been intimated to us. We bona fidely states about it. Therefore, we have not appeared. When this court has...
Just 1 minute, 1 minute.
Yes, my lord.
Have a pause in your submission. But looking to the SLP,
yes, my lord,
the facts, pleading, all relating to Order 7, Rule 11.
Your lordship, with
So
regard...
how can, why should we give interest to such orders? You have misrepresented the court and taken leave.
No, not sorry, my lord. It is not only with regard to Order 7, Rule 11, but both applications. What we say.
Mr. Birapatiran, there cannot be one SLP against both orders.
Normally.
No, even abnormally also. There has to be 2 SLPs.
Yes, my lord.
And undisputedly, there is one SLP.
Has been filed.
Undisputedly with a cause title that this SLP arises out of such and such CMP.
861.
CMP undisputedly involved
861.
151. Therefore, you are to, if you want to rectify, you go Supreme Court and file a review that, sir,
Your lordship,
petition has been
there is
undertaken.
no necessity for me to go again for another SLP against that order because it is dropped.
But you misrepresented.
It's a dropped, your lordship.
But you misrepresented Supreme Court and
So
got
not-
an order.
My lord, I have not misrepresented. I say I may be permitted to argue, file a review before the court, before the same court with regard to that issue.
Mr. Counsel, you have to understand, you have taken a leave.
Yes, my lord.
For reopening of a matter.
Yes, my lord.
On the plea.
Yes, my lord.
Foundation is 711 has been wrongly considered.
My lord, can I read the grounds in the SLP, my lord,
Yes.
for a minute?
Come to your... Synopsis is absolutely silent on 151. Come to get that ground where you have alleged on the 151 order. Entire synopsis is Order 7, Rule 11.
Question of law.
Page 17. Page 17 of this. Page 17 of this SLP. Page 17.
Yes.
Kindly see question of law. Yes. Your lordship, kindly read Miller, entire Miller. All Order 7, Rule 11. Then second.
1, 2, sub 711, all 711.
All. Even
So,
5.
Supreme Court has passed an order under misunderstanding.
Yes.
As if you are challenging 711. Argument also advanced on 711. Supreme Court formulated its opinion on Order 7, Rule 11. When SLP is against some other CMP. So therefore, I am not obliged here. I will observe. Your
lordships for a minute, your lordship. Take your lordships.
Your ground, page 17.
Your lordship's order for a minute, your lordship.
Which order?
This order, by which is under review, 861 order, my lord. At page number 14, my lord, in my review typesets, review petitions, annexer 2.
Just 1 minute. Page, what is the page you are referring?
14, my lord, 14.
40.
No, 14.
14.
The review typeset, my lord.
Yes. Yes, 14.
Yes, my lord. Your lordship's order, 10/3/2022. 10/3/2022, order dated.
No, 14. 14, it is only end of the order. End of the CMP
No, my
order.
lord. That is in the review petition.
14 in SLP or
review
14 in
petition
review?
328. my lord.
14 in review.
Review.
Okay, sorry. That is CMP order.
Yes, my lord. Here so-and-so appearing on behalf of the petitioner, in spite of appearance of a set of counsels on behalf of the opposite party, nobody appears at all at the time of call. Therefore, this matter is decided only hearing the learned senior counsel for the petitioner. Impugned order involved.
Mr. We should not waste our time in
Yes,
this.
no, my lord, in the
No,
back,
this is a matter.
in the
this is
back,
a
your lordship referred order 7 rule 11.
Maybe I have referred, doesn't mean that I have dealt with that. That has to be referred because there were 2 pieces were there.
Exactly, your lordship. When there is a 2 pieces of applications are pending, and your lordship is making an order on the ground that because nothing has been survived, on the ground the lease has been expired. Therefore, no discussion with regard to both applications in your total order, your lordships. Your lordship has not discussed either the one application under 151 or the other application under order 7 rule 11.
Okay, that's your submission. All
Yes,
right.
your lordship. Therefore, I want to read that particular portions of that, your lordship's order. The para number 4 refer to both applications. From the disclosures through paragraph number 134, this court finds CMP involved disposal of the application under section 151 of CPC, read with section 11 of CPC by the trial court, involving the civil suit 2 of 2016 on 4/5/2016. The impugned order available in Annexure 1 also involved the rejection of application under order 7 rule 11 of CPC. While challenge involvement, another civil miscellaneous petition also on both. In course of submissions, taking this court to disclosures through the pleading in plaint at paragraph number 7, 8, 9, 10 at page number 98 to 100, Mr. So-and-so, learned senior advocate, appearing on behalf of the petitioner, seriously objected the entertainability of the suit on the premises that there is a prohibition bringing such a suit after a long lapse of time. Further, for the nature involved therein, such a suit is also barred under the provisions of section 430 Companies Act. This will come only under order 7 rule 11 4D, that is barred by other law. That only the point my learned senior has argued. Then your lordship see, barred by the provision combination 213. It is at this stage of the matter, Mr. Learned Senior Advocate, appearing on behalf of the petitioner, bringing to the development in the legal provisions of the Mines and Mineral Department, hereinafter in short, be reflected at the Act, and reading through the provision at section 8A6, therein attempted to object the continuance of the suit otherwise for the lease involving in the civil suit, practically has already been come to an end 31/3/2020, even including the period of renewal last made. Mr. So-and-so learned senior counsel also submitted that further development taking place in the meantime, one leasehold area is already leased to third party and other part is taken over by the state as a owner of the property, Mr. So-and-so legal, the senior advocate, thus also claimed there is no lease involving the suit exists, petitioner company taking out the suit as a whole, so-and-so thus requests for appropriate order at this stage. Therefore, my learned senior counsel has argued on both the grounds. Not only the one ground alone it has been taken. Order 7, Rule 11. The company law bars the suit. Therefore, the Order 7, Rule 11D, barring the suit cannot be get along. That is the argument placed by Milanet Senior. Then your lordships pass the orders. In the above background of the matter, while attempting to challenge the impugned order, Mr. So-and-so learned senior advocate, appearing on behalf of the petitioner, contended that for the clear restriction in continuances of the suit and looking to the nature of the relief sought for, though the suit by way of injunction involving non-existence of lease and further for a period of lease having expired from 31/3/2020, there is no purpose in continuing with the suit. Continuing the suit will ultimately wastage of time and there will be no achieving of any relief ultimately. This court keeping in view the submission advanced by Mr. So-and-so learned senior counsel finds that suit of the opposite herein, the plaintiff is clearly based on the pleading by way of allegation that the ancestor of the defendant number 2 to 10 involving the suit had preparated and had a virtue of fraud become the director of the petitioner company, the defendant number 1, more particularly the petitioner hearing. Looking to the allegation of the present petitioner, the suit is grossly belated in time and this court has taken into account the age of the defendant 2 to 10 as disclosed in the plaint available at Annex 2 at page number 19 of the brief, also running parallel to the cause title disclosed in the impugned order annexer, and finds the detail so far relates to defendant number 2 to 10 as follows. Then your lordship given the particulars of the name. Reading through the cause title, the defendant number 2 to 10, taken note of it. Herein above, this court finds that most aged, the eldest legal heir members of the ancestor, the defendant number 3, being already 64 years at the time of filing the suit, also looking into the cause title, cause of action, at the instance of the ancestor of such a party, even taking into account of the age of the youngest member in the ancestor family, the defendant number 7, being 36 years, must have taken place several decades.
Come to your ground. What is the necessity of reading the order whole?
Yes, my lord.
Come to your ground.
Therefore, your lordship say in both the grounds, they may say the filing of the suit is
come to your ground of review. This is a review. This is not arguing appeal.
Yes, my lord, it's a review appeal.
So it's a review. Therefore, come to the grounds in review.
Therefore, my lord, according to me, my lord, in the review, what I am saying is, my suit is for an injunction restraining the respondent to...
No, Mr. Counsel.
The review points...
Sorry, review point. Come to straight to review point. You know the limitations in review. Review is not adjudication of appeal.
Now,
so therefore, come to review argument.
Yes, my lord, review.
What is the scope of a review?
Sir, review means, my lord, here, first point I am asking, I am not...
No, what is the scope of review? Under what circumstances?
I want the rehearing of the appeal on the ground.
Sorry, that is in appeal only, not in review.
Your lordship, on the ground that...
Please come to argument to sustain a review petition.
Your lordship...
What is that error on law?
What I'm saying...
What is that perversity?
Yes, my lord, I'm saying about it. Your lordship has dismissed the suit on the ground non-est because of the lease has come to the conclusions. But my prayer is injunction restraining 2 to 10 from attending the office or claiming to be the managing director.
Mr. Counsel, you are sure there may be two views.
Yes,
there may be two views on an aspect. That doesn't mean a review will be entertained.
Your Lordship,
So
because.
my view is there SLP, if the
Your
Supreme Court
Lordship, I'm
decides,
not
let them
saying,
interfere.
I'm not saying about it. Your Lordship say review will be that. What review I am saying
No,
is.
you are arguing in the substance of appeal, Mr. Counsel. I fail to appreciate. Come to straight to a point. 1, 2, these are 2 grounds, if at all, you can raise.
So,
on the entertainability of a review.
the first point, I am not appeared, my lord. No counsel has been appeared as per the decisions of this Honorable Court Division Bench. I may be permitted to argue the.
Okay, then.
That is next point. What is the prayer which has been granted in this suit is not the prayer, which we claim.
Okay, right. These are the 2 grounds.
These are the 2 grounds.
All right. Please. Yes, Mr. Mahanti.
Millard, with regard to hearing Millard, first is that his name was there. Second, Millard, I'll show from the case laws, even in absence of a counsel, that cannot be ground of review. That is the Supreme Court latest.
He's banking on a division-based decision.
No, the Supreme Court decisions, Millard, I am giving the 2 decisions, Millard, Supreme Court. One is of 18/8/2022, and it relies upon the year 1980 Supreme Court 2041.
Yeah.
So, Millard, kindly see with regard to first. Millard, let me, before showing this, Millard, I just want to show, because he has stated the counsel has argued with regard to 711 and 151. It's not. Millard, I have just argued for 151.
Only 151.
And 151, what I am saying.
I have made certain references.
No. Kindly see, Millard, what.
Involved there is.
No, my lord, kindly see. His case is a permanent injunction against a company. The defendants 1 to 10, 1 is the company and 2 to 10 are the directors of the company. Millard, what has he stated in his plaint? Plaint is, Millard, kindly see the plaint, Millard. Before going to this, Millard, the grounds. Just I will take 5 minutes on the plaint. Your Lordship, the paper book, if your Lordship.
Please take your seat. Please take your seat. Take your seat.
Now kindly see page 72, para 7.
Page 32.
72.
Of SLP.
Yes.
Or this paper.
This compilation.
Have you given a copy to them?
Eh?
Have you given a copy to
No,
them?
this is there, Millard. The compilation, this. This is the plaint, Millard. This is their document. I am reading.
From plaint you are reading?
Yes, I am reading the plaint.
Okay, page 32.
72. 72.
Yes.
The plaintiff states, Millard, plaintiff states while mining operation in respect of the aforesaid mines were being undertaken by first respondent company in which late Kumar Harishchandra Dev, the Rajkumar of Banai, had 54% share, was continuing as one of the founder director of the first defendant company. Plaintiff further submit the said Kumar Harishchandra Dev, namely the founder, started ailing physically and mentally from 1962, and his illness continued effectually, for which he was unable to look after affairs of business of the first respondent company for a long time. The plaintiff further submits that the management and the day-to-day business activities of the company were being managed by Mangobind Mahanti, managing agent, and one of the director of the company. Plaintiff further submits that said Kumar Harishchandra Dev, due to his illness, could not even move from Banai and was completely bedridden from 62 till his death on 8/5/1970. The illness of Harishchandra Dev is evident from letter written by Mangovind Mahanti to Kumar Harishchandra Dev on 14/6/1967. The plaintiff further submits that after demise of Harishchandra Dev, the plaintiff as one of the legal heir succeeded him being the legal heir all over the properties of the company. This is the only thing that he has succeeded. But company, my lord, is, my lord, of the shareholders. He is not a shareholder. He doesn't have any personal my lord, interest in the company, my lord. My lord, if your lordship kindly look into 41J.
No, Mr. Mahanti, is it necessary to go to this extent?
No, no,
now?
not at all. Why I'm saying?
No, because I'm not open.
No, because my friend was not there. I was why saying after this, then I have shown to your lordship with regard to these two properties. Property is stated in para 9. They themselves mentioned. Then your lordship kindly see, come to para 12, cause of action, 101. This is what I have shown to your lordship. Because I have said permanent, kindly see, no, page 75, para 11. Kindly see para 11 in the 6th line. But in spite of report, kindly come to my lords. But in spite of report, the said defendant 2 to 10 are continuing as the managing director of the company.
Mr. Mahanti, I will again come back to my thinking.
Millard?
Mr. Mahanti, I will again come back to my thinking process.
Yes.
If I reopen, then I can get into.
No, I don't require to reopen because he was not there. Why I am showing this? This I have stated here. Your lordship can see.
This is the basis I have considered.
Yes. Yes.
Therefore, I fail to appreciate a review being entertained.
Yes.
If he is agreed, let it go.
Yes.
Let him go.
Then, I'll just. Yes. I have two decisions. One is with regard to S. Madhusudan Reddy.
If decisions I am
Yes.
Grounds, if I may, with a small caveat, what essentially is exercise is to have a rehearing.
That para 11, you will just keep in mind, he has stated that I have filed the suit for declaration and injunction, but there is no declaration.
There is no declaration. Declaration, the appropriate court fee would have been given.
That is so. Here is only permanent injunction.
Only permanent injunction.
And permanent injunction 41J is bar. No personal, because he is not a shareholder. He simply say that I am a legal heir, and what type of legal heir, that also he doesn't disclose. So that is how, kindly see. Then now this will 18/8/2022 decision S. Madhusudan Reddy versus Narayan Reddy. This is for two things I have given. One is with regard to what is the scope of review, and second, Millard, para Millard, that with regard to 13 and 14. Kindly see Millard 13-14.
Page 13-14.
Para 13-14.
Para 13-14.
A glance at the aforesaid provisions makes it clear that a review application would be maintainable. One, discovery of new and important matters or evidence which after exercise of due diligence were not within the knowledge of the applicant or could not.
Absolutely. What is that material not taken into account?
No material.
Has relevancy in consideration, then in that event a review can be reopened. That's
Yes.
no issue.
Then kindly see, on account of some mistake or error appended on face of record, and for
Mr.
any other
Mahanti,
reasons.
Mr. Mahanti, your associates have not assisted you properly. I have a judgment on review. Allowing review application, I have taken care of 43 judgments.
Lord, I'm sorry.
Indicating the scope of review. Argument was argued, submissions were made by learned senior counsel Mr. S.P. Misra. What is the difference between appeal and a review? So in that context, I had to deal with about 42 judgments.
Miller, I'm sorry, I have not laid
My review judgment has been affirmed by Supreme Court.
Yeah. And Miller, para 14 is with regard
So
to
I am
hearing.
conscious. What are the grounds available to
Absolutely.
review a matter?
Miller, Para
Actually, I put him straight to a question and you argued two summaries.
So kindly, para 14, your lordship kindly take it.
Here in the same judgment.
Yes, same judgment,
Madhusudan
para
Reddy.
14. In
Madhusudan
Colonel
Reddy.
Avtar Singh, yes, in Colonel Avtar Singh.
Para
14, 1-4.
14 I have taken note, 13 and 14.
No, there kindly see, he was not given a hearing. That quotation, a review is not a routine procedure. Milord, here we reserve to hear Sri Kapil at the length to remove any feeling that party has been hurt without being hurt. So that 80 Supreme Court judgment I have given, where Justice Krishna said that he was not even noticed. Now, Milord, hearing cannot be a ground. So that is what I have given those two decisions. Then kindly see in that para 14 that the bold letters, a review of a judgment is a serious step. A reluctant to resort to it properly only where a glaring omission.
That is Justice Krishna Ayer's quotation.
Yes, and mistake or like a grave error has crept in judicial fallibility. The present stage is not a virgin ground, but review is not an earlier order, which is the normal feature of the finality. So this 80 Supreme Court I am giving to a letter where he was not even noticed. Then also he came in review. Then court said no, you can't. So 80 Supreme Court I have given, my lord, to your lordships.
No, one more judgment very recently I have got. Well, only I'll read two paragraphs. One paragraph. Paragraph 10 of the judgment.
Which judgment?
My lords, it is Ram SAHOO through Elas and others versus Vinod Kumar Rawat and others.
Copy.
Give copy. My lords, just one paragraph, paragraph 10. Mera para 6.2 of the judgment.
Para
6.2. That will be internal page
11 of 20 at the bottom.
11. Page 11 of 20, that you'll also find that page in the bottom.
Ask your associate to give it in HCC.
My lord, there, kindly see one para 10 is quoted from another judgment. I just read it out.
No, para, you are referring to para 6.2.
Para 6.2, kindly turn over that page, my
Just
lord,
1 minute.
and just come to para 10.
Page 12.
Page 12 in the bottom and para 10 quoted.
No, I'm not getting para 6.2.
This time from the-
Yes, 6.2 in the case
My
of
lord.
Lily Thomas.
Yes,
Hmm.
yes, Lily Thomas. And then next page, my lord. In the next page, para 10 of that. It is beyond any doubt or dispute that the review court does not sit in appeal over its own order.
That I have
As my
already
lord
said.
just
I
said.
I heard
I
that.
just, I also inherent power also your lordship cannot.
But even in spite of this argue, that was a case for review. Therefore, I interfered in the order.
Wherever it was, yes. But here it is a rehearing of the matter.
There the reason of interfering was there was attribution of fraud. Apparent on the face of the record.
That is the
clear ignorance of such aspect by the court, appellate court. So therefore, it's a case for review.
That's it.
And
When
it-
it falls under Order 47 Rule 1.
Mr. Das and Mr. Mahanti, this is a rare judgment of this court.
Yes, yes. I bow down. I bow down.
80 pages judgment I have given.
Yes.
And I have taken note of all review judgments there.
Well, this is the latest one. Maybe reiterating your lordship's views.
Absolutely, absolutely. These are off. This is 20. Mr. Mahanti shown a 22 judgment.
Yes, Madhusudan is 3 judges.
Yes, what are you finding from this 80 judgment, 1980?
80, my lord, with regard to hearing, review cannot be.
Mike.
Rehearing is not permitted.
So it is no reappreciation.
No, even their hearing was not there. Earlier in 80, there was no hearing. So they wanted a review. That also court said no. So that is how para 14, it has been reflected in this 22.
It's not a routine procedure.
Yes,
Okay, that
yes.
is in disciplinary proceeding.
Yes. No. That is in Avtar Singh case, my lord. Yes.
Avtar Singh case.
Yes.
But your lordship's right. They have extended to even to tribunals and disciplinary proceedings.
Yes, that's right.
Yes.
That's right, says.
Yes.
Second stage, it is only consideration of show cause.
Yes. Absolutely.
No opportunity of hearing is necessary.
Yes.
Therefore, yes, it is on that. It's
They say that Sri Kapil for the petitioner in paragraph 6, my lord.
Yes.
Sri, kindly see para 6 on the top right-hand side, on the top right-hand side,
Yes.
para 6, my lord, right-hand side, Sri Kapil for the petitioner, review, intervened and was heard. But we must fairly state that his client had not been given formal notice, and perhaps he had a grievance of not having been heard adequately. Yet, my lord, the court said that no, this can, para 12, kindly come to para 12. Para 12, 2043, right-hand side end.
Yes.
The review is not a genuine procedure. Here we reserve to hear Sri Kapil at the length to remove any feeling that the party has been hurt without being heard. But we cannot review our earlier order unless satisfied that material error.
Yes, I
manifest on the
said
face.
from the beginning, I said, what is that material error?
Yes,
Manifest
material error
on the
manifest-
face of record.
Yes, manifest on the face of record, undermines its soundness or results in miscarriage. Therefore,
And-
there was no hearing given, yet court said
And
no.
there is even clear judgment of the
Yes,
Supreme
so
Court.
therefore
There may be possibility of two views.
Yes.
Cannot be
Exactly.
brought in.
My lord,
external-
Your Lordship, may make one minute, Your Lordship. Section 114, section 114 and 47, review of the judgments, they say, class C only I'm reading. Your Lordship.
Section 114
114
of CPC.
and 47, CPC for order
Ah,
47,
yes,
order 47.
yes.
Order 47C. And who from the discovery of a new and important matter or evidence which after the exercise of due diligence was not within his knowledge or could not be produced by
Mr. Counsel, that is not a ground
Your
here.
Lordship, Your Lordship, only one, the section only.
No, you don't read the language. It will not help here.
Your Lordship, that
What is that
interpretation-
new material which was not available in spite of
Lordship,
due
what
diligence?
I am saying it, Your Lordship, in my case,
Yes.
the prayer in my suit is only restraining the defendant from 2 to 10,
Yes.
attending the office of the first defendant. There is no prayer against first defendant, but all the petitions were filed only by the first defendant, not by 2 to 10. 2 to 10 has never appeared, though appeared,
All right,
never denied.
All right, I conclude.
Never denied. Therefore, when the prayer itself is not there with them,
Had this.
the dismissal of the suits
G.
and allowing that applications is against.
Okay, all right. Had the submission of Sri G. Veera Pathiram, है, तो देखिए clearly, ठीक से. And assisted by, you are assisted by?
Mr. Rajaram.
His name is not there.
There's one more here lady.
Any local counsel,
Local counsel
J.
is there.
Pradhan, anybody?
Mr. Prijat.
SK Misra
Yeah.
is also senior counsel, J. Pradhan.
Now, Prabha Mohanty.
Okay, PS Mahanti. And from the other side, so Sanjit Mahanti and Sri Jankalyan Das, both senior counsels, assisted by Acharya.
And
Mr.
and I Acharya.
A. Acharya, I.
Acharya.
Acharya and Sandeep Das.
Yes, Sandeep.
Sandeep Das is.
I have to face the two senior counsels. I have to face the two senior.
No, there's no.
Even
Even
for
expert
one
might
respondent.
stand against
For a single respondent, both of them are appearing.
That's not a normal feature here, but that's a normal feature in Supreme Court. For one party,
Yes, my lord.
just in that gay
But
law.
my lord,
Gay
that
law,
may be,
how many lawyers, how many sets of lawyers?
my lord, but there may be a difference. Respondents will be there. Here, one respondent, they are appearing.
No,
for
no,
both.
in same trap, in same trap. So therefore,
Yes.
lawyers are benefited ultimately.
Yes, my lord.
Why should we stand in?
My lord, I want only things, I want only to have a chance to argue the entire things. I only the thing, if points will be referred, your lordship may give any date, we will come and argue the things.
Sorry, order reserved.
Great.
Yes. Thank you very much.
Item 13.
Yes, rest of the cases. तो ରହିଗଲା କାଲି ଏଇ ଦିଅ ପ୍ରତିଦିନ ଦି ଦିଟା ମ୍ୟାଟର ଦିଅ ଏ ବେଲ ଟା କଣ ହେଲା ବେଲ କାହିଁ ତାକୁ ଦେଇଦବା
My lord, I am for
bail will be taken up tomorrow.
My lord, I am for
Yes.
item 35, lord.
ଶୁଣ ଆଉ କଣ ରହିଲା 22, 23 matters will be taken out of list. Baki matter asibo, didita matter ei pratek din asibo. Bail ta tomorrow asibo, la positively. Bail ready huantu.
Lordship, bail.